Tomorrow, you mention other matters, you move it, it will come in the other list, and then I'll take up mentioning separately.
अपन ನಾನು ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ ನಂದು 3-4 ಸರಿ 4 ಸರಿ ಇದಲ್ಲ
ಕೊಡಿ ಎಲ್ಲ ಮುಗಿಸ್ಕೊ
ಏ ನಂದು ಅಲ್ಲಿ
ಎಲ್ಲ ಮುಗಿಸ್ಕೊ
ಇದ್ಯಾರು ಬೇರೆ
ಎಲ್ಲ
ಅಲ್ಲ ಸರ್ ಇದ್ಯಾವುದು ಬೇರೆ ಬೇರೆ
ಮಾಡ್ತಿದ್ದೀನಿ ನಂದು ಒಂದು
ಸರ್
ವಿಡ್ರಾಲ್
ಪೆಂಡಿಂಗ್
fellowship
Lord, I moved this matter here last week. Lord had given today as a day. Lord had given today as a day. I'm challenging the order of the National Company Law Tribunal that they have dismissed my application filed by the union. Their resolution plan provides absolutely nothing for the workmen. My urgency these maladies in Delhi. I'll make my submission so far as that is concerned. The difficulty that is faced may be taken up tomorrow, please. The difficulty is if they accept that resolution plan, then I am fixed on it.
Fresh matter. Fresh matter.
One more railway.
Fresh matters, please write fresh matter and give it.
Please.
Fresh matter.
This is a railway state officer has issued a notice. I think to pass an order against them. Similar order. They may be taken up similar kind of.
Fresh matter.
fellowship
DRT order challenge matter is 26/2025 Miss Avila. Position corrected absence.
DRT matters and legality matter. You may need their time basis because I hear it in the presence of the bank. They're wasting your time instead of going to
fellowship
Fresh matter.
fellowship one matter your lordship the borrower had challenged the surface measure before the DRT that has been dismissed and against that order he has approached this on court. There was an unconditional interim order, your lordship. The due is about 65 crores. I have filed application for vacating stay, your lordship. Nandu ಅಲ್ಲಿದೆ ಅದೇ
wait and give it in case you are
wait
Lord, 3 times date has been fixed. Three times date has been fixed by this honorable court, my lord. Fresh matter. Lord, not even posted for my lord. Yes, my lord. Today also my lord, date has been fixed.
My lord.
It's pending. ಸರ್ಫೇಸ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ಎಂಟ್ರಿ ಮಾಡಿ ತಗೊಂಡ್ಬಿಟ್ಟು ಬಿಸ್ನೆಸ್ ಕ್ಲೋಸ್ ಮಾಡಿ ಬೇರೆ ಬಿಸ್ನೆಸ್ ಮಾಡಿ ಫ್ರಮ್ ಪಾಸ್ಟ್ 3 years ಇಂದ ಸರ್
My lord, fresh matter.
Stay order. The land is not within the board without premises. That's school property.
My lord, fresh matter. My lord, tender process has been challenged. My lord. Fresh matter, my lord. Tender process has been challenged. One surfacey matter, my lord. My lord, I had moved it last week on behalf of the bank. The successful bidder, my lord, has deposited the entire amount in January 2025, my lord. Fresh matter. It's been 6 months, my lord. Now he wants. It's settled. What is it?
Your Lordship, MSME challenging MSME Council order. They have filed the writ petition. This honorable court has granted stay for that. So we have filed an IA to vacate the stay.
My lords, one matter I'm requesting for tomorrow, please, my lords. The urgency is that the petitioners herein are the blind students. There's a notification which says that 20 marks should be given for internal assessment, my lords. Second PUC students who have just passed out. My lords, in fresh matter. I'm requesting for tomorrow, please, my lords.
My lord, petitioners.
Matter was to execute the sale deed by the KIDB, my lord. But any day in the next week, my lord, not insist. At least next week.
My lord, I have filed my early hearing application in January. I'm a senior citizen. I obtained my law degree, but Bar Council is not allowing me to enroll. I want to practice as a lawyer, my lord. Old matter, by 24. CMR.
My lord, petty.
My lords, defreezing account, my lords. No, my lords, pending matter.
One pending.
Any day between 2 days, my lords. Thank you.
Lords, fresh
My
matter,
lord,
lords,
petition
Surface Act,
account.
order of possession passed against the enforcement. Kindly have it at 2:30, lords. Lords, the bank is taking possession today, my lords.
It's a fresh matter.
Lords, at least tomorrow, my lords.
My lord, petitioner's account has been freezed, my lord. Even I moved a IA also, my lord. I've already moved the memo.
Pending matter.
It may be taken up on Monday, my lord.
My lord, JM police.
It will be fixed depending on whether there is.
My lord, they are suffering
There is no
from.
place in the list. I can't have more than 11. So I'll give a date. And date, if it doesn't come, we come.
My lord, JM police. JM police.
Original documents already produced before this morning. Kindly tomorrow, my lord, and fight the. Tomorrow.
My lord, JM police matter, my lord, fresh matter. The petitioner is the SC/ST caste belongs. So the police sub inspector of the Mudibidri, he is charging FIR against her, my lord. And
My lord, one pending
lord.
matter, my lord.
One more, my lord, one more.
Here, police aren't registering a FIR on that.
Question.
GM police, 20th vacancy.
My lord,
Take it, you must file 482. How you are making filing rates? Up to you.
My lord, one more submission, my lord. My lord, impleading application rejected by the Honorable Rajya Dharmika Parishad, my lord. So, set us at the.
my lord, one.
The petitioner has obtained the interim order during the year 2022. At the time of obtaining the interim order, they have agreed to close the entire loan. Till date, they have not closed the.
ಟೆಂಡರ್ ಮ್ಯಾಟರ್ ಮಲಾಡ ನಾವು ಎಲ್ವನ್ ಬಂದಿದ್ರು ಕೂಡ ಟೆಂಡರ್ ರೀಕಾಲ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಇವತ್ತೇನು ರೀಕಾಲ್ ಆಗೋ ಚಾನ್ಸಸ್ ಇಲ್ಲ ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಇಟ್ ಅಟ್ 2:30 ನಾನು ಹಂಬಲ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡೋಣ
They are rising early. We have put a date.
ಎಂಡ್ ಆಫ್
ನಾಳೆ ಬರುತ್ತೆ.
My lord,
Serve on the respondent in advance.
ಎಸ್ ಮಲಾಡ ಐ ಹ್ಯಾವ್ ಸರ್ವ್ಡ್ ಆಫ್
My lord, this is a senior citizen matter where the respondent is a qualified purchase. No, my lord, it's pending.
my lord, these pending matter, my lord, GM Forest, my lord. In this, my lord, interim order was obtained on the ground that an appeal before the Deputy Commissioner for Regulation is pending. This is an eco-sensitive zone where the group of people are running resorts, my lord, which.
My lord, emergency parole. Mother is not keeping well. Kindly on tomorrow, my lord. Listen.
Your Lordship, this is a fresh matter. The UK Embassy has banned it. Kindly post it for tomorrow issue. The UK Embassy has banned my petitioner from traveling to UK. So kindly post it for tomorrow, Your Lordship.
My lord, surface matter, they have not.
Fresh matter, my lords. Infrastructure contract, my lords. They terminate the contract, my lords. I completed 70% of the work. They said time was the essence of the contract, my lords. Time was never the essence because there was an extension clause. It was my request for end of the list, my lords. Otherwise,
Sir,
tomorrow, my lords.
1960.
Tomorrow, my
Lordship, pending matter, right to.
Great.
My lord, surface
Great
matter,
rules.
they will not complied with the more than one group.
Lordship, pending matter, multiple memos were moved for right to be forgotten. Any day next week, your Lordship will start.
Fresh matter, now that receive right now, that demand notice has been issued. Tomorrow,
Sir.
Please.
It's a tender matter, Your Lordship. It's a tender matter, Your Lordship. They issued work order, Your Lordship. In spite of knowing that he is eligible to contest in the tender, Your Lordship.
My lord. Fresh matter. Pending matter, the date. Date. Yes.
It's a pending matter.
Hearing on IA is there.
Fresh matter.
Fresh matters, please write fresh matter on top and give it to the court officer. It will come. Fresh matter, you write fresh matter and give. It will come tomorrow or day after tomorrow.
Parole memos are more.
Mail birth ಕೊಟ್ಬಿಡಿ fresh matters. ನಾಳೆ ನಾಳಿದ್ದು fresh matters ಆಗ್ತದೆ. Yes. Yes.
ನಾನು ತಗೋತೀನಿ. ಇರ್ಲಿ ಪರವಾಗಿಲ್ಲ ಬಿಡು. ಸೇರ್ಕೊಂಡು.
Tomorrow, state, you just tell the state. Let them, no, and tell them specifically so that they can take advance instruction. Yes. Give it. Fresh matter. Right. No. Yes. Give it. Short date. Yes.
Adjournments, list 1, page number 1.
Small submission. In warning list.
Just wait. Warning list mention must be made only at the end of the list.
No, my lord. In the time for the respondent back, they have petitioner has challenged the sale proclamation issued by the DRT. On the scheduled date, the sale has not taken place. The WP may be.
You give a memo for disposal, you give it. Yes.
May I make a mention, my lords?
ಆಯ್ತು ಅದನ್ನ ಇನ್ನೊಂದು ಮೆಮೊ ಕೊಟ್ಟಿರಿ, it will come tomorrow.
May I make a mention, my lord?
Just wait. Yes.
Adjournments, list 1, page number 1, 1 to 3, page number 2, 4 to 9, page number 3.
My lord, serial number 7, my lord. 2 weeks time may be granted, my lord. Matter is settling between the respondent. I'll update settlement or I'll withdraw the matter, my lord.
At request, list week after next.
Much obliged, my lord.
Page number 3, 10 to 15, page number 4, 16 to 22, page number 5, 23 to 25, page number 6, 26 to 35, page number 7, 36 to 42, page number 8, 43 to 47, page number 9, 48 to 52, page number 10, 53 to 56, page number 11, 57 to 60.
Serial number 57, my lords.
Yes.
My lord, this matter pertains to cooperative societies, but it has, however, it has been come before your lordship, my lords. Serial number 57, my lords. Kindly direct the register to come before the appropriate bench.
Verify and list before appropriate bench at the earliest. Yes.
Please, my
Page number 12, 61 to 64, page 60.
Just wait. 62. Have you informed
state?
At request list next week. Yes. Just wait.
Page number 13, 65 to 68.
Yes. Then let it come in the. It's an old matter, is it? List the matter in preliminary hearing list on.
27.
The short date note.
24.
24. Yes.
Page number 14, 69 to 72.
My lord, I appear for the petitioner. Some urgency in the matter at their issues.
69.
Relist. Yes.
Some urgency.
25th. Corrected. 25th is the earliest date, if not today.
Regarding police protection, there's some demolition with respect to the.
Civil disputes, no property, no police protection. Let us see.
Page number 15, 73 to 77. Page number 16, 78 to 81. Page number 17, 82 to 84. Page number 18, 85 to 87. Page number 19, 88 to 93. 90.
At request, relist on.
Page number 20, serial number 90.
It has to be heard. Correct, sir. It has to be heard. Let us see. Correct. We can't help it. Let us see how to accommodate. You make a mention at the end of the list. We'll see what can be done. Let, so let us see. It has to come up on some other day. You file an IF early hearing. We'll put it up the list. Yes.
Page number 21, 96, 97. Issue 2, page number 1, 1 to 4, page number 2, 5 to 7, page number 3, 7, page number 5, 8 and 9, page number 6, 10 to 15, page number 7, 16 to 9, 18, page number 8, 19 to 22, page number 9, 23 to 26, page number 10, 27 to 30.
Yes.
My lord,
At request 47. Huh? Warning list is separate. That you can't mention now. Only at the end of the list you have to mention. You tell the court officer, he will look into it. Yes.
List 1.
Huh?
47.
Okay, let us see.
my
First
lord,
point is listed.
my lord, pertaining to DRT matter, my lord. 3 weeks time was granted, my lord, directing deposit 10 lakh rupees. I deposited 5,60,000. 4 lakhs, my lord, a little short of it. I'm seeking extension of time, my lord.
In my court, DRT matters, I'm not interfering. Anyhow, I list it, but you get ready to go take your other remedy. I'm not interfering in surfacey matters.
It may be out and tomorrow, my lord.
It will come, but I'm telling you, mentally be prepared. Whatever other action you have to take by way of substantive remedy, you take it. Where interim order is passed, it's not complied, I am not going to extend. Please take it from me. No equity in surfacey matters. Mentally you come prepared. Whatever order is to be passed, it will be passed. Yes.
List 1, fresh matter serial number 1. Likit.
Just give it, madam. Time is up. Yes. Next.
Likit. Serial number 1.
Yes, government.
I appeal for
Ashwath CM.
Yes.
So this
Just one. Yes. No, but who are you now? Who are you? What is your locus standi? No, were you a part of the?
Yes.
Correct, but now already 6 months is over.
6 months up. My lord, what has happened?
Already 6 months is up.
This
Now it's from January.
My lord, this tender is only for a period of 1 year. They procure these chicks who are 5 weeks old and supplied to all the Jilla Panchayats and Taluk Panchayats, where these are distributed to marginalized farmers and backyard farming, or ladies self-help groups, women self-help groups. We are a procuring authority, my lord. Here, what has happened is, my lord, the requirement is about 2.5 lakh chicks, and the tenderer here has already supplied 70% of the chicks, because it's a time-bound thing, my lord, for 1 year. So they distribute these chicks to all the marginalized farmers and people of farmers belonging to weaker sections and women self-help groups to augment their income.
So what do you say regarding the single bid?
What had happened, my lord, my learned friend, on the last date of hearing, my lord, there are 2 tenders. First, one tender was filed which he participated. At that point of time, my lord, it was declared that this petitioner, as well as the present successful bidder, were rejected on certain grounds, my lord. Now he has not. Then subsequently, fresh tender was called again. This is the second tender in which, my lord, they both were declared as responsive, and there was a third tenderer who was not non-responsive. Now, my lord, what had happened was there are 2 limbs to the technical evaluation. One was in form of a physical verification, and one was in form of documents, my lord. He has succeeded in the documents part, my lord, and the other requirement was that they will have to physically show to the department that they have infrastructure so that they can brood the number of chicks and supply it, my lord.
Correct. Now, in terms of that circular,
yes,
what is the exception in case of single bid?
My lord, in Tata Cellular's case, my lord, what it has said, the Supreme Court also had the entire tendering process. It is done only to find a best person and best quote, my lord. That is the principle followed in all the tenders, my lord. Here, this tender, being a socio-beneficial tender to the farmers and other marginalized weaker sections, my lord, what had happened was first tender has failed, in which he
No,
had
just
participated.
correct. Just go to page 47, the second clause. You just see how you are going to get over the second clause of the circular. Mike page 40, annexure D.
49 ಏಕಬಿ ಟೆಂಡರ್ ಕುರಿತು ಸೂಚನೆ ಮತ್ತು ವ್ಯಾಖ್ಯಾನವನ್ನು ಉಲ್ಲೇಖಿತ ಹಾಗೂ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆಗಳಲ್ಲಿ ನೀಡಲಾಗಿರುತ್ತದೆ. ಏಕಬಿ ಟೆಂಡರ್ಗಳನ್ನು ಸ್ವೀಕೃತವಾದ ಸಂದರ್ಭಗಳಲ್ಲಿ ಸದರಿ ಏಕಬಿ ಟೆಂಡರ್ಗಳನ್ನು ತಿರಸ್ಕರಿಸಿ ಮರು ಕರೆಯುವುದು ಟೆಂಡರ್ ಆಹ್ವಾನಿಸುವ ಅಧಿಕಾರಿಯ ಪ್ರಥಮ ಆಯ್ಕೆಯಾಗಿರಬಹುದು. ಉಲ್ಲೇಖಿತ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ ಆಗಿರುತ್ತದೆ. ಆದರೆ ಏಕಬಿ ಟೆಂಡರ್ ಪರಿಗಣಿಸಲೇಬೇಕಾದಂತಹ ಅಸಾಧಾರಣ ಸಂದರ್ಭಗಳಲ್ಲಿ ಮಾತ್ರ ಟೆಂಡರ್ ದರಗಳ ಅಂದಾಜು ಮೊತ್ತಕ್ಕೆ ಹೋಲಿಸಿದಾಗ 5% ಹೆಚ್ಚುವರಿಯಾಗಿದ್ದಲ್ಲಿ ಅಥವಾ ಲಾಭಾಂಶಗಳು ಹೊಂದಿದ್ದಲ್ಲಿ ಈ ಸಂಗ್ರಹಣೆ ತಂತ್ರಾಂಶದಲ್ಲಿಯೇ ದರ ಸಂಧಾನ ನೆಗೋಸಿಯೇಷನ್ ಮಾಡುವ ಕಡ್ಡಾಯವಾಗಿದೆ. In this, my lord, what
have you followed that?
Yes, my lord.
Huh?
Yes, my lord. It is, he has given 1 rupee below the estimated cost of the chick. The estimated cost of the chick was 130. Now the tenderer has offered at 129.
Okay, let us file your statement.
Yes, sir.
Let us see 6 months is up now. What?
And his appeal under 16 also is pending.
Appeal is pending.
He has filed an appeal for the government also.
My lord, I represent the fourth respondent, my lord. I wish to make a
inform that appeal.
Let us see. But now 6 months is up now. How we can
We have
interrupt?
filed, my lord, the petition, my lord.
No, correct. But 6 months is up now. Now what we can do?
Kindly see annexure, my lord, E, that has been, my lord, dated 4/3/2025. Petition was filed, my lord, on
Even
14/3. Not immediately after 10, within 10 days, my lord, we have filed it. Due to vacations, my lord, it was not, my lord.
correct. Let us see. Now you take a stand in writing. I'll have it next
But
week.
there are judgments to say that, my lord.
So let's see. We'll see.
Exceptional circumstance should be, my lord, recorded in.
That we'll see. Statement of objections to be filed by the next date. Relist the matter on date code.
My lord, the fourth respondent may also be permitted to file his objections, my lords.
Yes.
1st
Next.
of July. Serial number 2.
My lord, interim order may be extended.
My lord, now, my lord, there is no entry order because.
No, that we'll see.
At interim order.
Yes.
Serial number 2.
Interim order may be extended. Last time, my lord, your lordship protected, my lord, interest. That interim order may be extended.
Orally, it was instructed to me that nothing will be done. My lord, now that thing is, he has already supplied about 1.5 lakh chicks.
No. Now, any action that I've already ordered, any action taken by respondents would be subject to orders to be passed. No equities to be pleaded. Let us see.
But he's already supplying the.
Correct.
That, my lord, that we cannot hold, my lord.
Correct. I am not passing anything. I only said it. Everything is subject to orders to be passed.
Yes,
You take your stand in writing. He is specifically adverting to second para of the circular. What is the procedure followed? And that there is no malefites.
Yes,
there is no loss.
Yes,
you put it on record. We'll see. Yes.
2. Serial number 2.
Lord, this is similar to the matter yesterday which your lordships heard.
Same.
Two other companies. That was
Same matter or different matter?
It's a different matter, my lord. That is listed. Yesterday's matter is listed in list 3 at serial number 8. We have given notice also, my lord. If your lordships.
Just one minute. List 3 there. Now that will take it with this only, isn't it?
Yes.
Identical submission.
Identical, my lord. Similar. The companies are different. Only one small difference is there.
I just wanted one clarification. At para 34.4 and 34.5.
There in this writ petition, man? Yes. I have it. Master circular we are relying on.
Correct. Is it so that there is a clause in the master circular?
Yes, my lord. Your lordship saw it last time, my lord. It's there in part of this. I can read it.
I just pointed out.
Yes, my lord. If your lordships would take, my lord, at annexure S, which begins at 292.
S begins at 259.
Huh?
S begins at 259.
There are two circulars, not 259.
282.
At 282. Clause 73 is there, my lord.
Page?
Page 282, para number 73. Subject to provisions of the circulars, etc., all stressed loans which are in default in the books of the transferors are permitted to be transferred to ARCs. This shall include exposures classified as fraud as on the date of transfer, provided that all responsibility of the transferor in respect of continuous reporting, monitoring, filing of complaints with law enforcement agencies and proceedings related to such complaints shall also be transferred to ARC. So the third respondent, having assigned it, it cannot do anything in the matter.
Correct, but now, as on that date, it was, that was lifted, isn't it? That
It was closed. The proceeding, my lord, they had filed a complaint. The police had filed a closure report. Based on that, they had withdrawn the fraud classification. Now this is second round, de novo, by a party who has no authority.
Under the master circular,
yeah,
it's only the assignee.
Master circular, my lord, is of the Reserve Bank, and that, my lord, is this is issued exclusively for this transfers. If your lordship should go to the opening portion of S, the object of issuing this was, my lord, your lordship may recall, when the SURFACI Act was enacted, the object was that difficult loans which banks are faced with should be able to be transferred to asset reconstruction companies. So the Reserve Bank was regulating it to say how a asset reconstruction company should work, how the transfer should take place.
You're correct. So my point was,
yes,
that you had made a submission that once it's assigned to an asset reconstruction company, in terms of the master circular, it is that asset reconstruction company only that must pursue this fraud application.
Please, my lord. That's the only limit. And one is that. Second aspect is, after the police report.
No, correct. That you go to the next paragraph.
Yeah.
Now you point out the master circular. Yeah. Insofar as your submission that once the investigation authority gives a report.
Yeah.
Then under the master circular you cannot revisit.
Yes, my lord. That is clause number 6.4. Your lord, may please go to page 306, my lord. This is the master circular.
Yes.
At 306, para number 6.4. Closure of fraud cases reported to RBI. Bank shall close fraud cases using closure module where the actions are stated below are complete. 1. Fraud cases pending with LEA and court are disposed of, and examination of staff accountability has been completed. That second one is their internal, if somebody is responsible.
So you're saying under 6.4.
Now, my lord,
first
we come at the first. There's a police report followed by a withdrawal of the fraud classification. Now they want to just harass me, my lord.
But no doubt on this ground we can stay because the master circular itself says that.
Please, ma'am.
Correct. But after the order of the apex court, if they were to recall stating only that principles of natural justice have not been followed, then they are always empowered to redo it. Isn't it?
No, my lord. Oh, that's one aspect is that, my lord. Second aspect is, if because of natural justice they did not comply and they want to redo it, who can redo it is a jurisdictional issue. Because of the master circular, third respondent cannot do it.
That is. So now, where is that B report? Insofar as the petitioner herein is concerned.
Yes, my lord. Annexure
C.
P, my lord.
C. Annexure C. Closure.
The closure report is annexure C at page 56.
Just one minute. Now this page 306 is a part of annexure S.
Yes, my lord. S1, my lord.
Huh?
S1. Your lordship saw annexure S beginning at 259.
Yes.
That is relating to transfer. Annexure S1 begins at 292. This is relating exclusively to fraud. At 292, your lordships will get it.
Now, where is the B report?
The B report is annexure
C.
P, no?
C.
C, my lord. Annexure C, page 56. That's in the other case, it was a B report. Here it's a closure, my lord.
Page
56, my lord. Page 56, 23/6/23. This is to inform you that your complaint against so-and-so to senior police officer has been received and processed and recorded in the police station number so-and-so. Respondent has been interrogated, statement obtained, complaint is closed.
No, but then this says pending with LEAs is, just go back to 30.
My lord, LEA is law enforcement agency. Your lordship saw not, LEA is law enforcement agency. And at the bottom it is addressed, my lord, your lordship may see, to Sandeep Mehra, so-and-so bank.
The identical.
Identical. Only difference, my lord, is in the case which your lordships are now holding, the report of the police says it is closed. In the other two cases, it says it is B report is filed. No case is made out. That's the only difference.
The petitioners have sought to challenge show cause notice at annexure R. Page.
Challenge, my lord, is to annexure R at page 128.
Whereby the respondent number
3,
3 bank has called upon the petitioner to make it stand insofar as the proposal to classify the petitioner's account as under the caption of fraud in terms of the RBI master direction. The senior counsel appearing for the petitioner would submit that in terms of annexure S1, which is the direction of the Reserve Bank, in terms of 6.4.1 Roman 1, the fraud cases report to RBI are mandated to be closed where the cases before the law enforcement agencies are disposed of. Attention is drawn to the endorsement issued by the law enforcement agency at annexure C. Full stop. It's submitted that thereafter the law enforcement agencies have not pursued any other proceeding insofar as the bank.
Yes.
Full stop. It is further submitted that the liability of the loan has been transferred from the third respondent bank to the fourth respondent asset reconstruction company, and in case of such scenario under the master directions of the RBI, it is the fourth respondent that is to pursue an application to classify the petition as fraud and cannot be at the instance of the third respondent. In light of the contentions raised and noticing the stipulation at annexure S1, the third respondent bank is stayed from proceeding further.
I have sought, my lord, a stay of annexure R, that is the show cause notice. All further proceedings.
Accordingly, there would be stay of annexure R and further proceedings till the next date. Emergent notice
12691.
34. Petitioners at liberty to serve. Counsel appearing for the standing counsel, if any, for the third respondent as well as respondent 1 and 2.
Please.
Now this we have to list it with that third list matter.
Yeah. In this there's one more, my lord. 2.1 is there. In 2.1, facts are exactly the same. Only small difference is that in this case, my lord, there's a B report at page 42.
That is only difference.
That's the only difference.
Annexures?
Annexure is a D at page 42. And the show cause notice is annexure Q.
You're seeking stay of annexure?
Q. Annexure Q.
There would be stay of the show cause notice at annexure Q. Law enforcement agency report badlo B report at annexure D. D page
Annexure D, my lord, is dated 6/4/22
This is by the court,
by the police.
by the
B
police,
report is filed by the investigating agency police.
Annexure D, B report. Annexure Q, show cause notice. Other stay. Same order, same.
In the third list item, my lord, it's identical to the second one.
Correct, but then let it, since I've ordered notice,
Please,
given, let them be present.
please, ma'am.
And then you can make a request to the court officer. I will, because I had not gone through the file. It had come in office objection. I went through, so I noticed that.
Please, ma'am, I'll
But-
wait, ma'am.
Yes. Yes.
My lord, there's some difficulty to comply with office objection in the other matter because file could not be given.
Yes.
If the file is given, we'll comply now.
Yes. Good. Next.
3. Dinesh Rao.
The first petition is relating to plywood and veneer industry, my lord, for which no license was required prior to the amendment.
Forest Act, good Forest Act.
I think in these matters, my lord, lordship has directed them to file written statement of objection.
No, it had come up day for yesterday. I in fact sought for a week's time, your lordship, because they were not present. I had made my submissions very clearly that they have to seek permission from the state level committee. The objections are
In terms of,
in terms of the notification of the government of India.
just point out.
The notification is.
Otherwise, if your objections are ready, I'll
No,
have it.
objections are ready.
If it's ready, I'll have it next week. You file it. On that date, we'll hear the, insofar as it.
Tuesday.
Even I will have an opportunity to look into the objections.
No, I'll serve. There is a
Statement of objections to be filed by the respondent. List the matter in the same stage on
next Tuesday.
Tuesday.
It's Tuesday.
Cause list 2, my lord, serial number 1. 3,
Yeah.
same matter.
List so and so along with this matter.
Please.
List 3.
List 3.
List 2, cause this serial number.
Serial number 3.
List 2, serial number.
List along with this matter.
Interim order may be extended.
Interim order and operation is extended till the next date. Yes.
Serial number 4. Ajay is here.
My lords, applied to the Mysore Corporation, my lords.
Death certificate. May have to go before the local bodies.
My lords, I also think so, my lord. But
I'll
it's
ask
classified as GM res.
I'll ask them to verify, and if it here, then I'll have it tomorrow. Office to verify regarding roster.
May I just make one subject? Madam, I was just saying Geeta Devi madam my lords can dispose it off.
No, if it,
I feel what
I don't step on others' toes. I have
yes. No,
Release tomorrow.
My lords,
Office to
instead of
verify
tomorrow, can
regarding,
it be on 19? Or I have some.
Office to verify regarding the roster, and if matter and relist it on 19.
Serial number 5.
Yes.
Lord, I appeal for the respondent.
Now, his only contention is that
Please, my lord.
appointment was on compassionate grounds. So
Yes.
his contention is that technically speaking, his caste may not have any relevance. You take your
Yes.
stand in writing. Interim protection will give. We'll hear the matter.
Lord, may I suggest, my lord?
Yes.
My lord, even if he is appointed on a compassionate appointment, my lord, under 4C, he has not used the certificate for the purpose of seeking appointment.
Under 4C.
Under 4C, of the Karnataka Scheduled Caste, Scheduled Tribe, Other Backward Classes Appointment Act of 1990.
He is required to.
If he is appointed against the SC quota, my lord, then he has to produce the validity certificate from the District Caste Verification Committee. I don't know whether his father has been appointed on a compassionate ground, on the scheduled caste category, or what we don't know.
Now, who is the employer now?
Mother has expired.
No, just 1 minute. Who is the employer?
That he has to say.
Employer is the DC, Deputy Commissioner. I have produced Annexure A.
It's a government. Government.
Government.
We'll ask the government to clarify. We'll ask the government.
I'll seek clarification from the Lord. For even for the DC also, I appear. I may be directed to take notice. Then, my Lord, your Lordship may call next week. If they are not appointed, my Lord, liberty may be reserved to the contesting respondent to challenge under 4B or 4F.
That we'll see. But here now, the Deputy Commissioner will have to be impleaded as an additional respondent.
Yes, my Lord, not as a DCVC.
Correct. You implead, I'll give you permission, Mr. Hegde.
But I will.
No, as an employer, you implead him. I'll give you permission now itself.
Yes.
The petitioner.
1 minute, my Lord. I will take your Lordship through the.
No, we need not go into merits. I'll give you interim protection.
Yes.
Now, what they are saying that in the event your appointment is towards a reserved post, though under compassionate appointment, then the DC will have to first clarify whether your appointment is to a reserved post, though under compassionate appointment. Because then otherwise it should have been under some other post, not reserved, some issue they're raising.
Deputy Commissioner is already party. Second respondent is the Deputy Commissioner.
No. Just 1 minute. There's a difference between DC in the capacity of
chairman. Chairman.
So you make him as your employer. In the capacity you describe and make him. Petitioner is permitted to array the employer, namely the Deputy Commissioner, as an additional respondent. Oral request made is acceded to. EGA accepts.
For even also for them also I appear.
Jagdish accepts notice for the said respondent, necessary amendment to be carried out. Full stop. Taking note of the contention of counsel for the petitioner that the appointment was on compassionate grounds, it is submitted that the question of inquiry regarding caste certificate may not arise. Full stop. However, learned counsel C. Jagdish submits that it needs to be verified as to whether the appointment even under compassionate ground is insofar as a reserved post, in which event caste certificate may be relevant. Matter requires consideration. In the interregnum, there would be stay of annexure F and further proceedings till the next date. The respondents to file their statement of to take their stand in writing list week after next. Interim order to be in operation till the next week.
One more request.
Till the next date.
One more request. In the prayer column and the interim prayer column, but some mistake has crept in. But instead of stating the court, honorable court, it is typed as tribunal. But I may be permitted
to correct the prayer and interim prayer insofar as deletion of the word honorable tribunal and replace it with the word honorable court.
6. Ajay Prabhu M.
Now we will stay provided you are going to pay some maintenance.
Please, subject to. I will need to put.
How much?
Lord,
don't think too much.
No, my lord. Because he himself
so how much?
said,
how much?
10,000. Please.
Actually, in all these matters, you must instruct the Deputy Commissioner and AC in terms of the latest order of Supreme Court, unless there's a clause in that gift deed or settlement deed, then 23 is not attractive.
The coordinate bench of this honorable court, when sitting in GM, previously almost about 2 roasters ahead, had observed the same thing. In fact, a letter was sent to the Principal Secretary Revenue Department to verify these things and to rectify the orders. Unless there is a clause, don't pass the order because.
Correct, but now in light of the Supreme Court order, you can circulate it because unnecessarily matters are piling up. If that is the position, then there is no jurisdiction to intervene.
Communication with these people, my lord, with the Principal Secretary. I think the
then one matter will.
One matter he may be
will reiterate that.
And advise him, my lord. Then accordingly he will take action.
One matter will ask him to appear through VC.
Yes.
You just tell in any one
Yes,
of the
yes,
matters. Now in this matter, there's no clause.
There is no clause, my lord.
You're
It
sure?
is, yes, my lord. My lord, I have annexed settlement deed itself, my lord. Annexure B, page number 30.
Page?
30.
No, because I'm going to summon the principal secretary, so you tell me correctly.
Please, my lord.
There's no clause.
There is no clause.
Just recheck it. Recheck it.
There is no clause, my lord.
We'll ask
It,
him to be present through VC.
Today, my lord?
No, no, we'll fix a date.
Yes, sir.
Let him come through VC.
Yes, sir. Yes, sir.
The petitioner submits that in terms of the settlement deed, there is no clause mandating maintaining of the senior citizen as contemplated under the express express provision of section 23 of the act.
Please.
Accordingly, it is submitted that matter ought not to have been entertained. Reliance is also placed on the judgment of the apex court in
Sudesh Chikkara also, Ramti Devi.
in so and so. ನಾನು ಕೊಡ್ತೀನಿ ಅದು Uka's judgment.
in civil appeal number 174 of 2021. Page number 15, my lord.
In Sudesh Chikkara versus Ramti Devi and other civil appeal 174/2021.
Please.
Accordingly, it is submitted that the authorities have no jurisdiction to entertain matters where there is no such clause. For the say of the government regarding entertainment of such petitions in light of the law laid down by the apex court. Now you suggest either judicial order and we close it and make an observation, or what? Wow.
No, my lord, I suggest that we call the principal secretary. My lord, in this matter can be passed over at 2:30. I'll request him to appear in VCU at 2:30. We'll be done with it.
So I'll just orally we can tell him. To
Yes, yes, ma'am. Orally we can tell him. 2:30 I will.
Not today.
Yeah.
We'll have it relist the matter in the preliminary hearing list.
At the same time, I will take notice to hand summons to.
A short date. Next, 20th.
Yes.
In the preliminary hearing list.
I will take notice to other side, my lord.
In the interregnum, there would be stay of the order at annexure A.
Okay, Friday.
Subject to petitioner paying maintenance that would be 10,000 per month to the first respondent. AGA accepts notice for the second respondent. In light of repeated cases arising wherein petitions have been entertained despite absence of express clause, there is a requirement to ensure that the observations of the Supreme Court in the above mentioned case is taken note of and suitable instructions be made to the concerned to take note of the order of the Supreme Court. In light of the same, the principal secretary revenue to be present through video conference on the next date.
Please. 7 Arjan, 8. 8 Ajay Prabhu.
8.
8. DM police.
My lord, in this matter, my lord, notification is issued under
Yes.
Unlawful Activities Act, my lord. Why, my lord, the one political party which is not at banned, my lord, was, my lord, given for rent, my lord, by the petitioner. My lord, hence the, my lord, this notification is issued and, my lord, my premises has been locked.
List 2 serial number 1.
But what is the procedure?
My lord, the lease period is over, my lord, on 30/11/2023 itself. And he has also given an undertaking, my lord, that he will not give the premises in future to any.
Correct. Under the act, there is no provision, is it?
There's no provision.
Huh?
No. Only notification they have issued, my lord. Upon notification.
No, but under what power you seize it now? There must be some provision providing you to seize the premises. Which act is this?
Lord, Unlawful Activities Act, my lord.
I'll have it on Monday. You just point out from the provision of the act. I'll have it on Monday. Please. We'll take note of it and we'll dispose, but you point out on what power.
Even otherwise, my lord, it will not, my lord, affect to this case because.
No, that's a different matter.
Please.
But if they're doing it, we need to know under what power they're doing.
Please.
Then we'll see, we'll make an observation. They can do it only if there's power under the act. If there's power to seal, then there must be power to deseal. If it's not there, anyhow, we'll take note of your statement in the end and dispose it. On the legal position you make.
Please.
This is the matter in preliminary. AG accepts notice for the respondent. This is the matter in preliminary hearing list. Monday.
Please. Grateful.
Now, if there's no provision, then you cannot do it. Yes,
please.
2, preliminary matter, serial number 1, Ramesh KR, AGA. Serial number 2, serial number 2.
Pass over.
3 urgent 4, Shiva Prasad.
Pass over.
Serial number 5, Vedavyas 5. Serial number 5.
My lord, this matter was heard yesterday, my lord.
Malini Vinay.
My lord, the affidavit, they had not mentioned that tenancies. My lord, this matter was heard yesterday. My lord, what has happened is.
No, correct. Now, who's for the bank? Yesterday also she was not there.
No, my lord, I had served a copy yesterday, my lords.
Serial number 5. Serial number 5.
My lord, I had served a copy yesterday.
I'll pass over. By the time I do the fresh matter, if she comes, you telephonically inform her. I'll take it up now. Just telephonically inform her to come.
I'll try and find. I don't have. Yes, ma'am.
You have a number? No.
I'll find out.
Pass over. Or Esra ko board.
Serial number 1, Ramesh KR.
Next.
Serial number 2.
This is a case wherein the petitioner has been, his name has been registered in the sheet of Rowdy's. Now, my lords, the coordinate bench.
District 2, serial number 2. 12285.
Yes.
Let's see. Kindly see annexure B, page number 21 is the impugned order. In this matter, my lords, there's no notice that has been sent to him. His representation was also not considered.
Page?
Page 21, my lords. This is the order directing the respondent number 3 to enter the name of the petitioner. This order was not served to me. No notice was served to me, my lords.
So under which act, what is the provision? Is there any express provision of hearing?
No, my lords. The coordinate bench has issued.
This is under which act? Orders are passed under which act?
Police manual. Karnataka police manual.
Under that, is there no procedure?
There is no procedure prescribed. That is why this coordinate bench has laid down certain guidelines, my lords.
A judgment. And that notice must be given, etc.
My lord, yes, my lord, that is the guidelines given in that judgment, my lord. But in this case, my lord, page number 22, my lord, they say that they have served the notice on him, my lord. That is in the order, my lord. Their contention is that, my lord,
He is not served.
it's false. And
then you verify and produce the record.
I will verify and produce.
So then we'll stay this. The counsel for the petitioner submits that the order passed in terms of the Karnataka police manual.
Police manual.
Including the petitioner in the Rowdy sheet.
Yes, sir.
The Rowdy sheet has been made without following the procedural safeguards as laid down in the WP 4504 of 2021 and connected matters in the case of BS Prakash versus State. Full stop. It's further submitted in terms of the guidelines. The petitioner needs to be afforded notice even before order is passed, final order is passed. In light of the same, the order at Annexure
B, my lord.
is stayed. Respondent state to file their statement of objections and move for vacation of the interim order. Full stop. Now, according to you, if the procedure needs to be redone, then you simply file a memo, withdraw it, and you do it afresh.
Yes, my lord. I'll make submission in
Correct.
that regard, my lord.
Huh.
With
So-
liberty, this
Correct.
petition may
So
be
then you
dismissed.
move a memo
Yes,
and you withdraw it
please.
and redo it afresh. There ends the matter. So the preamble of the order says every saint has a past, every sinner has a future. So the petitioner is a saint. Huh? We'll accept that. Yes.
Great.
So in all these matters, if procedure is not followed, simply move a memo, withdraw it, and you redo it afresh.
Please.
Yes.
Great. 4, Shiva Prasad.
Seeking a writ of mandamus.
Yes.
Let's petitioner has made an application seeking allotment of 2 acres of land for industrial purpose. Annexure B, minutes, page number 26. The district level single window clearance committee has approved my project. Page number 26, minutes. Thereafter, I make a representation. It has not been considered. My only prayer before this honorable court is
AG accepts notice for point 1.
notice has already been issued.
Who appears for KDB?
Mr. P.V. Chandrasekhar.
Huh?
Mr. P.V. Chandrasekhar.
Not Council Shri.
Hello. Name is not
P.V.
shown.
Chandrasekhar is directed to accept notice for respondent number 2.
2 minutes.
3.
3 over.
3 also notice was issued. Notice is
Only
awaited.
appears.
PV Chandrasekhar.
Council P.V. Chandrasekhar directed to accept
He has
notice
already been served,
for R3. Office to show the name of so and so representing R2 and R3. List the matter in the preliminary hearing list. Date good.
26.
Yes.
List 1, serial number 9. Jan Pasha 9.
Appearing for the petitioners. My lords, we are filing the affidavit and handing over the check of.
The petitioners put me on terms, my lord.
What is it?
But para 5 of the affidavit, my lord. This is not in consonance with what was expressed yesterday. Allotment, can you take para 5, my lord? Under circumstance, without prejudice to the relief sought in the instant petition and pending consideration of the same, I am depositing a sum of rupees 5 lakhs by way of DD, drawn and so in favor of 1 out of the total amount of 10 lakhs. Because the interest, my lords, is to be added to this, at least the post judgment, my lords. Within a period of 4, and my lords, he says the balance sum will be deposited within a period of 4 months from the date of handing over of the keys of the premises in question.
No, now, of course, we'll impose condition, but on the remaining amount, well, lakhs, for the time being, you take it that we will accept.
My lord.
Take it also that we may give a direction to hand over possession. The remaining amount, you have to pay interest, then I can
My
prevail
lords,
upon it.
the building is not in good condition.
That's a different matter.
It is in lock and key.
That's a different matter.
I have to spend more than 6-7 lakhs, my lord.
Maybe, but now your property is caught in under this. If you have to go in appeal, it will be a never-ending exercise. Only exit for you is to come with a reasonable offer so that he can at least.
Petitioner is a woman, my lords.
You take your
Even from 2019, rents are due, my lords.
We cannot enter into that. That's the order of the court is like that. We cannot tinker with it. And he also cannot take a stand. If at all you are going to pay some bank rate of interest, we can at least suggest to him to look into it. You have a look at.
And Lord, second submission, my lord. Lord, again, Lord, subject to the outcome of the petition. So he wants the petition to be pending. So let him-
No, correct. We'll dispose it off.
Please.
After taking note of some reasonable interest on the remaining amount till it is paid. And if there's any default, then the petition would revive.
Please.
Petitioner is aged about 70 years, my lord. She is a senior citizen, my lord.
This is
Single
under,
woman.
This is under some act. I have no discretion to intervene in this matter. You give some proposal of interest, you think, get instruction and you come back. We will see. When do you want it? affidavit filed is taken on record.
I'll file my
My lord.
response, my lord. Base time for me to file my response, my lord.
No response required.
My
Let
lord,
us see.
it may be passed over, my lord.
Huh?
It may be taken
reach-
up to that.
It won't reach, you make a mention, please. If he comes forward with interest on the remaining amount, then you make a joint mention, I'll see what is to be done.
Please, abort.
Passed over.
Pass over.
Yeah.
Taken tomorrow, my lord.
Tomorrow.
Tomorrow, please.
My lords, it may be passed on 2:30, my lords.
No,
We'll
today-
seek in.
Today at 4 o'clock, we have something I have to rise, so there won't be any time. We'll have it tomorrow.
Please.
But take it from me that only if you suggest for interest on the remaining amount, I can at least put it forward to him. Otherwise, he will not be in a position to get consent.
Please.
Even after we give, he will have to ask. That's a different matter. But at least there would be some bona fideness with some observation we can make.
Obliged.
Yes.
Then
Your Lordship, kindly pass over to 2:30, Your Lordship. I shall present the memos
Well, it's the same
with the DD, Your Lordship.
Well, it's the same matter. Sale taken place. Sale taken place. Auction purchaser paid 24% of the money. This honorable court shown certain diligence, my lord, they've undertaken that they're going to pay the entire money. This honorable court passed an order on my lord 17/4/2025, stating that my lord is going to pay the entire money with my lord solicitation to the auction purchaser. Thereafter, my lord, 4 adjournments. Yesterday also the matter was listed. They're supposed to my lord give the DD today, and my lord now they are seeking the password.
To 2:30, Your Lordship. The reason being is
Pass over. Let us see. Pass over. Yes.
11.
For the petitioner, my lord.
My lord, my name is shown
We are unable to see the court
Anyhow, you think about it, Will. Yes. You just think about it. But I'm saying it's in your own
Parallel
interest.
to this,
In your own
the
interest.
the time for my lord listing was reduced from 5 days to 2 days, 3 days.
But that is not
So
being implemented.
thinking my lord that this will expedite the process.
No, no, correct. It will expedite. Think about it, we'll see. Realist. We'll relist it week after next.
Interim order may be extended, my lord.
Interim order, earlier grant is extended till the next date. It's in your own interest. You look at it, consult the association and look into it. Any changes you suggest, we'll ask them to look into it. If you feel that 1 or 2 changes are required, it can be asked. And finally, afterwards, what has happened is, I think now they've said there are some minimum objections that have to be complied. In case of memos, some meeting was held. So that could also be observed in the passing, saying that even now suppose you do the scrutiny, whether everything is completed or not, it will come before the court. But the judge will be in a position to see basically what has been done. Scrutiny, meanwhile, will take its time. What is not complied, if urgency is there, definitely even without complete compliance, it will come before the court. We can make observations, think about it.
Please.
Yes.
17.
Petitioner has a file for parole, my lord. On the last date of hearing, this matter was listed and this honorable court has directed to produce the record, my lord.
My lord,
And he has been,
and last occasion, my lord, it was directed to me to check whether his father
Father,
has any
father.
objection. He has no objection.
No objection.
Maybe.
So you just tell me the facts now. Tell me the facts.
my lord, the petitioner, my lord, he has been convicted for offense 366 of IPC and under section 4 of POCSO Act, my lord. And has been sentenced for 7 years, my lord.
7 years imprisonment.
Imprisonment.
He has served now.
He has been served almost 3.5 years, my lord. 3 years, 5 months has been served, my lord.
3 years.
5 months.
As on date.
As on date, my lord.
Now he applied for emergency or general parole.
He has been applied for general parole, my lord. And same has been rejected, my lord.
What is the reason assigned?
For money repairing, my lord.
Repair of house.
Yes, my lord.
Now what is the endorsement of the report?
Yes, my lord. Annexure
A.
Yes, my lord.
You just take me through the important paragraphs. Page 10.
Page 10, my lord.
Yes.
But on the last, my lord, on last line, my lord.
ಯಾವುದೋ ಒಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಪೆರೋಲ್ ಮೇಲೆ ಕೊಟ್ಟಿರೋದಿದೆ. ಪೆರೋಲ್ ಮೇಲೆ.
My lord.
Yes.
The reason that was given is not house repair, my lord. It is for agricultural activity.
Yes, anyhow. Tell me. Tell me.
Yes, my lord.
What does the report say now? You just read the relevant paragraphs.
Paragraph last, my lord.
Page 10.
Page 10, my lord.
Read.
ಸದರಿ ಅರ್ಜಿ ವಿಚಾರಣೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶಿಕ್ಷಾ ಬಂಧನಿಯ ತಂದೆ ತಾಯಿಯವರು ಸುಮಾರು 40 ವರ್ಷ ಹಿಂದೆ ಊರು ಬಿಟ್ಟು ರಂಗೇನಹಳ್ಳಿ ಹತ್ತಿರವಿರುವ ಮಂಡಲವಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತಾರೆ. ಸುರೇಶ್ ಈತನ ಪತ್ನಿಯ ಆಕೆಯ ತವರು ಮನೆಯಲ್ಲಿ ಕೃಷ್ಣಾಪುರ ಗ್ರಾಮದಲ್ಲಿಯೇ ವಾಸವಾಗಿರುತ್ತಾರೆ. ರಂಗಪ್ಪ ಹಾಗೂ ಕುಪ್ಪಸ್ವಾಮಿ ಅವರು ಜಂಟಿ ಹೆಸರಿನಲ್ಲಿ ಕೃಷ್ಣಾಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 23ರಲ್ಲಿ 2 ಎಕರೆ ಜಮೀನಿನಲ್ಲಿ ಕೃಷ್ಣಾಪುರ ಗ್ರಾಮದಲ್ಲಿ ಸ್ವಂತ ಮನೆ ಸಹ ಇರುವುದಿಲ್ಲ. ಖಾಲಿ ನಿವೇಶನ ಮಾತ್ರ ಇರುತ್ತದೆ. ಸದರಿ ಜಾಮೀನನ್ನು ವಿಭಾಗ ಮಾಡಿಕೊಂಡಿರುವುದಿಲ್ಲ. ಈತನು ಕೃಷಿ ಜಮೀನಿನ ಉಳುಮೆ ಮಾಡುವ ಸಲುವಾಗಿ ಎಂದು ಹೇಳಿ ಪೆರೋಲ್ ಮೇಲೆ ಬಂದು ಯಾವುದಾದರೂ ಕಾನೂನು ಬಹಿರ ಕೃತ್ಯ ಮಾಡಿ ತಲೆಮರೆಸಿಕೊಂಡಿರುವ ಸಾಧ್ಯತೆ ಇರುವುದರಿಂದ ಹಾಗೂ ಆತನ ಮೇಲೆ ದಾಖಲಾಗಿರುವ ಪ್ರಕರಣದಲ್ಲಿ ನೊಂದವರ ಮನೆಯ ಸಹ ಕೃಷ್ಣಪುರ ಗ್ರಾಮದಲ್ಲಿಯೇ ಇರುವುದರಿಂದ ಈತನು ಪೆರೋಲ್ ಮೇಲೆ ಕೃಷ್ಣಪುರ ಗ್ರಾಮಕ್ಕೆ ಬಂದಲ್ಲಿ ಗ್ರಾಮದಲ್ಲಿ ಪುನಃ ಗಲಾಟೆ ಆಗುವ ಸಂಭವ ಇರುವುದರಿಂದ ಸದರಿ ಸುರೇಶ ಸನ್ ಆಫ್ ಕುಪ್ಪಸ್ವಾಮಿ ಈತನು ಪೆರೋಲ್ ಮೇಲೆ ಬಿಡುಗಡೆ ಮಾಡಬಾರದಾಗಿ ಗ್ರಾಮಸ್ಥರ ಶಿವಶಂಕರ CBN ಚೆಲುವರಾಜು ಹಾಗೂ ಲಿಂಗರಾಜು ಅಲಿಯಾಸ್ ರಾಜು GM ಬಿನ್ ಮುನಿರಂಗಪ್ಪನವರು ಹೇಳಿಕೆ ನೀಡಿರುತ್ತಾರೆ. ನಂತರ ಜಾಮೀನುದಾರರಾದ ಸುರೇಶ್ ಅವರ ಪತ್ನಿಯಾದ ಸುಪ್ರೀತಾರವರು ಹೇಳಿಕೆ ಪಡೆದಿದ್ದು, ಹೇಳಿಕೆಯಲ್ಲಿ ರಂಗಪ್ಪ ಹಾಗೂ ತಮ್ಮ ಮಾವನವರಾದ ಕುಪ್ಪಸ್ವಾಮಿ ಅವರು ಜಂಟಿ ಹೆಸರಿನಲ್ಲಿ ಕೃಷ್ಣಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ನಲ್ಲಿ 23ರಲ್ಲಿ 2 ಎಕರೆ ಜಮೀನು ಇರುತ್ತದೆ. ಸದರಿ
There is
ಜಮೀನು
no other disqualification.
No,
there is no need.
Huh?
or only because of this report, my lord, it was rejected.
Where is the final endorsement? They have not passed any order or they have rejected it?
They have just rejected, my lord. That's it.
Where is that? Or they have not passed any order? Endorsement at annexure A. A is the report. A is the report. Annexure A is the report. So
Yes, my lord.
technically there is no endorsement.
They have not produced it, my lord.
Huh?
They have not produced that endorsement.
Or they have not rejected.
That he should
My lord.
reject my regard.
My lord.
ಒಂದು ಕೊಡು ಅಷ್ಟೇ.
They
They have
just
rejected
given-
or not?
They have just given an endorsement saying
Where is that endorsement? Do you have it?
Next A itself, my lord.
No, A is the report, isn't it?
Yes, my lord.
Huh?
Annexure A is the report, my lord.
Huh.
Endorsement has not been given, my lord.
So then we'll direct to grant after imposing condition.
Yes, my lord.
The petitioner has sought for being enlarged on parole. Before the respondent authorities and has sought for setting aside the report at annexure A, whereby respondent authorities have made out an opinion to the superintendent Central Jail Shimoga
Yes.
to the effect that there is no recommendation to make out a case for releasing him on parole. Full stop. The case of the petitioner that he had sought for parole for the purpose of agricultural activities of the land belonging to his parents. It's his further case that he is the only son.
He is the only son, my lord.
Only son. Full stop. It is submitted that the refusal to recommend in terms of the report at annexure A is on 2 grounds. One, that there may be threat to the victim who stays in the same village. Two, that his wife is not agreeable for the petitioner to be released on parole. Full stop. Next, counsel for the petitioner submits that his relationship with his wife is strained. Now she stays different place or in the same house?
In the same house, my lord.
Is strained. Full stop. AGA upon oral direction of this court has verified views of his father, which is not referred to in the report, and the father has stated that he has no objection for release of the petitioner on parole. Full stop. Next, it is noticed that the petitioner has been in
My
a
lord.
served sentence.
My lord,
of,
one submission, my lord. Petitioner itself a father, my lord. He is appearing on behalf of the convict, my lord.
ಅದು petitioner ಬದಲು ಕಾನ್ವಿಕ್ಟ್ ಅಂತ ಕರಿ ಆಮೇಲೆ petitioners ಅಲ್ಲಿ ಫಾದರ್ನ petitioner ಅಂತ ಹೇಳಿ. The convict has undergone sentence of 3 years and 5 months as on date. That is roughly half of the sentence imposed. It is settled position as laid down by the Apex Court in the case of Asfaq versus State of Rajasthan, 2017-15 SEC, page 55, regarding the objective of grant of parole, which would include keeping in mind temporary release of the prisoner to look after lands, and parole may be granted in order to ensure integration of the petitioner into society when he eventually goes back. Taking note of the report, it is to be noticed that the grounds made out in the report are not on relevant consideration. Full stop. The ground made out is a matter that require consideration in the facts of the present case, noticing the sentence imposed, comma, that petitioner has completed about half of the sentence, comma, that it is his first application for parole, comma, that the views of his parents have also been elicited. Full stop. Other aspects are matters that could be taken note of by imposition of appropriate conditions. Full stop. Accordingly, the petition is allowed. Respondent number 2 is directed to release the.
My lord, respondent number 4, my lord.
Respondent number 4 is directed to release pass orders, taking note of the above observations regarding his application for parole. Such order to be passed within 1 week from today. The court is prima facie of the view that the petitioner's application for parole could be considered for a period of
30 days.
My lord,
so you say
my lord, we are sought for
30 days.
60 days, my lord.
for
My lord.
45 days.
My lord, the reason, my lord, he has been already served for off.
That's a different matter. For 45 days. The fourth respondent is at liberty to impose conditions as per procedure and law applicable to ensure return of the detainee to the jail. Accordingly, petition is disposed of. Registry to communicate this order to the jail authorities through electronic mail. Yes.
18.
Yes.
That fishing right was 18, that writ petition number 14/266.
305.
Yes.
305.
That fishing right was granted to the society, that for period of 5 years, that 2020 to 21, that, and it is end of this year, that June of 30th, that.
Till June of
30th
June 2025.
5, that. Now what happened, that in the meanwhile, that the respondent has extended the period, that 1 more year,
till
25-26, that. Your lordship may kindly see that Annexure D is the demand notice, that. Page 23, that. That to renewal of that fishing right for the period of 25-26, that 5,90,000 to 209, that.
Yes.
Now
Now you are ready to pay that amount.
That we are ready to pay the amount, but what happened, that the respondent has not followed the amended rules, that 2014, that what was happened, that the lease was granted to the society, that the prior to amendment there is an 500 rupees has been fixed for per hectare, that. Now it is reduced into 300 per hectare, that. Now what happened, that they have not followed that rules, that. We are ready to pay that 300 for hectare, that.
He hasn't paid the amount, my lord. 1/4 is the demand. 1/4/2025. A month later, my lord, we've called for a fresh tender. That is, my lord, at Annexure F. Page 26. In fact, this matter had come up earlier. The Lordships had passed an order saying that subject to outcome of the writ petition on, my lord, 10/6/2025.
Now what has happened?
It extended further 1 year.
Now, my lord, I'll have to verify, my lord, if the tender has already been completed.
Find out.
Yes.
Find out. Now regarding his say of renewal amount, he's saying that it's
So he's still not paid it. He should have at least come forward and paid that amount.
He's saying it's
Kindly
2 months up.
The 5 years completed for this
Demand
month.
is
only.
Just a minute. Now
Demand
he's saying
Yes, my lord.
it's 300 rupees per hectare according to
Rules 14, 2014 circular, amendment, just person month. It's
Put it.
ಅದರಲ್ಲಿ your lordship may kindly see that 2014 ಅಲ್ಲಿ second para
but you verify whether after this 2014 there is any amendment.
Please, my lord.
Prima facie, it appears to say that it is reduced per hectare to 300 rupees.
I'll verify.
He's saying that you have now they have
My demand is higher, my lord.
They have calculated as per 500.
Please, mother. They have taken all that previous period of 3 years that amount has been calculated, mother.
You find out.
I'll verify that.
And we are ready to pay that hectare in that 300 rupees.
Let us see.
He should at least come forward with that amount, my lord, to show his bona fides.
No, you-
Anyway, now, my lord, I don't know what is the outcome of that tender process.
Find out.
Yes.
But you must have a check or demand draft ready. You can cancel it later by the next date to show your bona fides.
Yes.
You calculate as per 300, keep it. We will find out.
Please.
Relist the matter in the preliminary hearing list on. Learned counsel for the petitioner submits that he is ready to pay renewal fees in terms of the circular dated, amended circular dated 27/8/2014. Yes. But you demonstrate your bona fides by the next date.
Please, mother.
19.
Relist on date.
Interim order may kindly pay.
What is the interim order granted?
That interim order, mother, what happened?
There
In
is
the
no
meanwhile,
interim order.
mother, call for fresh tender, mother.
No,
There
let
is
us
no
see.
interim order.
Let us see. Any action taken by the respondents would be subject to the, we have already ordered.
Order, mother.
Let us see.
You continue, mother.
Yes.
Please, mother.
19.
You keep the DD ready.
So, you are ready to pay, mother, that amount was fixed, mother, 300 rupees, mother.
This is surfacey court, so the government advocate also, like the bank, will not accept merely I am ready.
I'll bring it.
You have to show.
Please, ma'am, please.
Yes.
19. Jay Kumar.
Yes.
The petitioner running a recreation club, my lord, and applied for the registration before the sixth respondent, my lord. The sixth respondent insisting the petitioner to get NOC from the respondent police, my lord, and Patan Panchayat.
Our judgment, we will consider.
No, but now the imposition of condition.
No, the first prayer, lordship.
Correct.
That time, that won't come now. That is only after registration if they insist.
Correct.
Now for registration of an association,
my lord,
just the coordinate bench judgment, we will follow that.
No, his prayer B.
Yes, prayer B.
Just show what is that?
Prayer B.
He's saying
that is NOC is not required. Annexure D.
Not required.
NOC is not required from the police for registration and association.
That is the position.
Yeah, that's the position.
As per the.
But first prayer, he cannot seek for the first prayer now.
For the coordinate bench of this court, order, my lord.
Annexure D, you know.
Annexure D, my lord. Page number 27, my lord. Relevant page, my lord, page number 31. Last para.
Last
para. Page number 31. The last para, my lord.
Yes.
Shall I read, my lord?
Yes.
But in the light of the order passed by the coordinate bench of this court, Supra, which was in fact following earlier orders passed in several coordinate benches of this court, I deem it appropriate to direct respondent number 6 to consider the application filed before him for registration of the petitioners association and pass appropriate orders in accordance with that, without making any reference to the jurisdictional police with regard to activities of the petitioner, unless it would come within the ambit of what is directed by this court.
What is
in the-
directed now? Where is it said that there's no, NOC is not required?
NOC is not required.
Where is it stated in that previous judgment? But I will take it that NOC is not required.
But the first prayer,
Yes, yes.
that is premature.
Yes, yes. These are bread and butter cases. That even I did, even you did, even he is doing.
Yeah.
Petitioner has sought for issuance of writ of mandamus directing respondents not to interfere with activities of the petitioner association.
No, this association has not yet been formed, your lordship.
Correct, full stop. Petitioner has also sought for issuance of writ of mandamus to direct 6 respondent to register the petitioner association in terms of the Karnataka Societies Registration Act.
Please.
Without insisting for any NOC from the respondent police authorities.
Yes.
Please. Police authority and 7th respondent, my lord, Patan Panchayat also.
As well as 7th respondent. But we don't know whether, now even Panchayat not required, is it?
No, panchayat is not required. No, panchayat is required subsequently for certain if they
Not
are.
for registration.
Not for registration.
Full stop.
My lord,
So far as
my lord, 6th respondent directed the petitioner to get NOC
where is
from.
that? Where is that?
But orally directed, my
Ah.
lord, there is no specific.
The registering authority ಏನು ಓರಲ್ ಹೇಳಿದ್ರು ಅಲ್ಲಿ ಅಲ್ಲ ಅಲ್ಲಿ it is noticed that petitioner had made an application for registering it, the entity under provisions of the Karnataka Societies Registration Act. Full stop. Insofar as insistence which is stated to be oral as regards NOC from the police and the Patan Panchayat is concerned, AGA submits that such condition cannot be imposed at the time of registering the society. Full stop. Insofar as the other relief of protection that is sought for, including respondent authorities not to insist on obtaining license to carry on lawful activity, is a relief that could be considered only after the petitioner is registered under the provisions of Societies Registration Act. In light of stand of learned AGA, the respondent number 6 to register application of the petitioner, if otherwise is in order without insisting on NOC from the police or the Patan Panchayat. Other reliefs are kept open to be raised at an appropriate point of time. Accordingly, petition is disposed of.
Your lordship, that NOC subsequent to registration, let it not be construed that from the panchayat whatever.
Just to state, after registration, in order to start functioning, whatever lawful requirements, including NOC from requisite authorities, as is mandated under law in force, requires to be obtained.
One submission, my lord. My lord, the office has shown the name of petitioner, master main instead of mastermind, my lord. In the cast title also, in cast title.
Office to rectify the name of the petitioner in the order sheet. But your description is correct. Your description is correct.
Description correct, my lord, but in the
ಆಯ್ತು ನಾನು ಹೇಳಿದ್ದೀನಿ.
uploading in the.
Yes.
20. Rakesh Gilbert.
My lord, appearing for on behalf of petitioner counsel, kindly pass over, my lord.
Don't reach after, if you pass over in GM roster, no pass over.
Petitioner counsel had requested me to kindly pass
It's
over.
okay, we'll have it on a different date.
It's
What is
only
it?
for consideration of a
request that has been made by the petitioner to
For?
the R2 for KEDB
For?
to register a sale deed in their favor.
Uh,
So that is what there must be some conditions which they have to comply with. Probably if a copy is served, my lord, I can make necessary.
You serve a copy.
Yes, my lord.
A copy to be served. It's a fresh matter, is it?
Please.
Land council so and so
Vasudevan.
undertakes to appear for respondent number
2.
2.
This state.
Yeah, accepts notice for the first respondent. So it could be disposed of.
Could be disposed of.
Isn't it?
Yes.
So relist the matter in preliminary hearing list on, you give him copies
Yes, ma'am.
immediately.
I'll furnish.
23rd.
Please.
Serial number 21.
My lords, I appear for the respondent in this matter. There seems to be some issue in this matter. I'm trying to find out, my lords. I would require a 10-day time. Interest component, my lords, is not paid to the petitioner. It is a motor vehicle accident case. This honorable court has directed that the enhanced compensation be deposited in a fixed deposit. There seems to be certain issues, my lords.
Lord, it is admitted fact that, my lord.
No, correct, but now, so how are you going to
Correct,
solve?
correct. That's exactly, my lords. I have requested them to look into what can be done and what should be done. In fact, not can, what should be done. So
Lord,
kindly
since
grant me a
1.5
10-day time, my lords. I'll sort this out, my lords.
Some arrangement will have to be made to pay interest and then you recover it from by holding an inquiry. You'll just look
My
into
lords,
it.
just grant me 10 days time, my lords.
No, my lord, sir.
I'll sort it out, my lords. I'll really, we require a little more time.
My lord, such object, my lord, since 1.5 years, my lord, petitioner has to pay her college fees, my lord. She is
My lords,
pursuing her
it's
LLM,
just
my
the
lord.
second time I'm seeking time.
Let us
I'll
see.
definitely come out with something in 10 days, my lords.
Lord, petitioner is living separately from her family, my lord.
All your grievance is genuine. We've directed them to solve the issue. Let us see.
My lord, she is in final semester of LLM, my lord. She has to
My
pay
lords,
fees.
my lords, if I have to make allegations, they have not given the details of the claimant to the office. So because of which, my lords, at the first instance, nobody appeared, my lords, before the office. I don't want to make all these allegations and counter allegations. I'll see what best can be done. my lords.
10 days date. 2nd of July.
Grateful.
Let us see. Let us see.
Grateful.
The
I'll
money
do
has to be
something.
paid. If they have to pay, they have to make some arrangement. Let us see. Yes.
Grateful, my lords. Grateful.
22.
Already objection.
Oh, correct.
This we have
Yes.
already filed. Not here at 22.1 and 22.2.
I'm for the petitioner's counsel in 22.3.
Yes.
These are members of a cooperative society who are allotted sites by MUDA after acquisition. The facts are like this. The petitioners had purchased the lands in a layout formed by private owners directly, and they even built the houses. Then MUDA said that is an unauthorized layout and demolished our houses. Thereafterwards, the land is acquired. In the interregnum, we filed writ petitions seeking regularization. Now, while the litigation was in progress, by a resolution dated 21/3/2023, MUDA passed a resolution as per Annexure A to allot the sites in favor of the petitioners. Now, this was given effective on 15/12/2023. Solely on the basis of the order passed by this honorable court in a review petition dated 19/4/2023, which is placed before the court as per Annexure C. May I just read out the relevant portion of the order.
You're referring to page in which writ petition?
22.3, 12449.
Page?
Page 50, page 40. Annexure B or C?
B, sir. Reviews.
Annexure B, page 33. Relevant part at page 55. Entire history of the litigation is traced. Kindly come to para 7 at page 55.
Yes, please read.
In view of the subsequent events which have taken place after the judgment dated 27/2/2023, we direct, kindly mark it, we direct that notwithstanding the judgment dated 27/2/2023 passed by this court in writ appeal number so and so, it would be open to Mysore Urban Development Authority to take an action for allotment of the sites in favor of the petitioners in WP number so and so. At this stage, Learned Counsel for the Mysore Urban Development submits that suitable action for allotment of sites shall be taken. He gives an undertaking. It shall be taken in terms of the resolution dated 21/3/2023 within a period of 8 weeks from today. Accordingly, we were given the allotment letters on 15/12/2023, Annexure D. Sale deeds have also been executed. However, the resolution based on which we were given the allotment letters itself came to be rescinded by a subsequent resolution by a GO passed by the government on 30/11/2024 as per Annexure E, page 76.
That has not been challenged.
That is questioned and it is stayed.
In WP number?
WP 33513 of 2024. An interim order copy is also placed before the court.
Now what is the challenge?
Now what has happened is we never come under any of the beneficial schemes under which a controversy arose in respect to the Honorable Chief Minister's wife. Pursuant to the sanction granted by the...
This is nothing to do with that.
Nothing to do. Now there, the wife of the Honorable Chief Minister was said to be a beneficiary of a rule allotting 50% of the land, acquired land, where the acquisition was, where the land had been utilized without proper acquisition. In our case, it is an admitted fact, we had purchased it way back in the year 1982. Built houses, those houses came to be demolished. Subsequently, land is acquired and subsequently a resolution is passed. It has nothing to do with the 50/50 rule which was in operation. However, in order to show that it is acting bona fide and against all the allottees are subjected to the order annexure G, which is the provisional attachment order made by the respondent officer. Page 83 may kindly be seen. There are several classes of beneficiaries, or rather allottees who are proceeded against in the matter. Kindly come to page page 105.
Now what is the status, present status of these proceedings?
These proceedings pursuant to this, we have now been issued with a notice by the adjudicating authority proposing to prosecutors. It is at this stage we are before this honorable court. Now, I'll just show one sentence. So far as B.M. Parvati, the chief minister's wife, it was alleged that she is a beneficiary of 50-50 rule. In our case, that rule was not in existence on the day the allotment letters came to be issued in our favor, because it was rescinded as early as on 27/10/2023. So that rule was not even in operation. We have been allotted in the month of December, 2 months thereafterwards. However, kindly turn to the facts alleged against us. Page 124 is the relevant part. The opening sentence: illegal allotment in the case of Chamundeshwari Nagara Sarvodaya Sangha. That is our society. Page 124. Illegal allotment in the case of Chamundeshwari Nagara Sarvodaya Sangha. A total of 48 sites have been allotted as compensation under section 50/50 scheme during the financial year 2023-24. The details of the 48 sites tabulated below. Absolutely no substance in that statement. Totally false. Nowhere in the proceedings or the resolution of the MUDA 50/50 rule is invoked. More importantly, we have been given the benefit of these allotments pursuant to an order of this honorable court and an undertaking given by the counsel for the MUDA in the review petition annexure B, which I have already brought it to the notice. There is not even a semblance of a reference to the court proceedings, and absolutely contrary to the directions issued by this honorable court. Now we are proceeded against and this order has been passed. So it is the validity of this which is under challenge. Incidentally, contempt petition has also been filed, and that contempt petition is also pending before this honorable court.
Contempt against?
Contempt against MUDA officers for rescinding the allotments made.
This is a fresh matter, is it?
This is a fresh matter.
First time it's coming.
No. It had already come up.
What is it?
I believe mattered. Notice was ordered on the interim prayer.
No order is passed.
After notice, court was. Now the urgency of the matter is, we have been slapped with a notice to appear before them on 18th. Page 196. Huh? Okay. 202 may kindly be perused. 204. 202. Okay. Tomorrow is the date fixed for our appearance.
Page?
Page 201.
Show cause notice at page 202.
Yes.
But they've given a notice to you to reply, is it?
To appear.
To
appear tomorrow.
No, but where is the appearance mandated?
May I request the court to kindly
You have been asked to make a reply.
Both the parties are given opportunity to file
Page.
page 207.
Yes.
Liberty to raise any legal issues on or before the very first day of compliance, so that the decision of the authority will be part of the proceedings, having heard them on the first day of compliance. It is made clear that no adjournment for filing of objection will be allowed after the first date of compliance, and thereafter for filing the reply at the most only 1 week adjournment can be granted. The issues which do not impact or constraint in giving justification reply to the core issue of confirmation PAO will not be considered separately and will be heard at the time of argument. Further, both the parties are given the opportunity to file the written submissions of oral arguments highlighting their contentions. It is also made clear that not more than 1 hour will be allotted for the opportunity of being heard, including the final arguments, and the time will be allotted prior to the beginning of the hearing. This may be extended if in course of oral hearing, bench is convinced that the nature of issue is complex, warrants additional time for oral arguments or for to understand the issue. Further, each submission, whether written or oral, will be taken into consideration by passing the order under section 8.3.
Yes.
Lord,
we have also received a further notice directing us that oral arguments are fixed on 18/6 at 2:30 p.m. I'll place a copy just now. We have received the.
You have submitted reply, sir. Lord, the writ petitions are not maintainable. Please have a look at the relief at, there's no marking of page number, but have a look at the relief sought. There are two relief sought. The first one, relief A, is to challenge.
12449.
Yes, Lordship is right.
Yes. The final prayer.
The final prayer. The final prayer. The first relief is to challenge a provisional attachment order, which is passed under section 5 of the PMLA, which has a shelf life of only 180 days.
180
days. It has shelf. Beyond that, it does not survive.
Under section?
Section 5 of the PMLA. The second one is a show cause notice issued under section 8. And the settled principle is that a show cause notice does not give rise to a cause of action. Now, my lord, would your lordship kindly have a look at those two provisions under which the attachment order as well as the show cause notices have been issued. First, would your lordship kindly have a look at section 5. Before that, my lord, since it is relevant, please have a look at the definition of proceeds of crime at section 21U. Lord, proceeds of crime under the PMLA. At the heart of the offense of money laundering is proceeds of crime. So therefore, it would be profitable to understand what exactly is this proceeds of crime.
Now, technically, I'm saying before entering into further argument, you're saying that in terms of section 5, this is valid for 6 months.
Yes, 180 days. Maximum.
Huh?
Maximum is 180 days.
So technically it would expire on
that day.
Which day?
If I file the complaint.
Once, if I, thereafter, my lord, the adjudicating authority and the rate will take over.
After lapse of?
Provided I have filed the complaint within 30 days. Provided I have filed the complaint before the adjudicating authority, and I will take your lordship through the provision, my lord, then it will be clear. Before that, my lord, please have a quick look at what the proceeds of crime would mean under 21U. Proceeds of crime means 21U. If it is EBC, it could be page 10. Proceeds of crime. Clause U of subsection 1. Proceeds of crime means any property derived or obtained directly
or indirectly, please see sweeping language, by any person as a result of criminal activity relating to a scheduled offense or the value of any such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country. So broadly what it means is that it is any property which is derived or obtained directly or indirectly as a result of a criminal activity relating to a scheduled offense. That is what it means. Now please have a look at section 5, under which the provisional attachment order was passed. It is found under chapter 3, which is titled as attachment, adjudication and confiscation. This is the civil part of the proceedings that can be initiated under the PMLA. The criminal offense is stated under section 3. Section 5, attachment of property involved in money laundering, where the director or any other officer not below the rank of a deputy director, authorized by the director for the purpose of this section, has reason to believe, the reason for such belief to be recorded in writing, which has been done in this case, on the basis of material in his possession, that there are two requirements. A person is in possession of any proceeds of crime, and B, such proceeds of crime are likely to be concealed, transferred or dealt with in any manner which may result in frustrating any proceedings relating to confiscation of such proceeds of crime under this chapter. He may, by order in writing, provisionally attach such property for a period not exceeding 180 days from the date of the order in such manner as may be prescribed, provided that no such order of attachment shall be made unless, in relation to the schedule offense, a report has been forwarded to the magistrate under section 173 of CRPC, or a complaint has been filed by a person authorized to investigate the offense mentioned in that schedule before a magistrate or court for taking cognizance of the scheduled offense as the case may be, or a similar report, complaint has been made or filed before the corresponding law of any other country. Provided further that, notwithstanding anything contained in the first proviso, we can skip this and go to subsection, the third proviso. Provided also that for the purpose of computing the period of 180 days, the period during which the proceedings under this section is stayed by the High Court shall be excluded, and a further period not exceeding 30 days from the date of the order of vacation of such stay shall be counted. 2 and 3 are important. The director or any other officer not below the rank of deputy director shall immediately, this is the safeguard. This is the safeguard against abuse of power. After attachment under subsection 1, forward a copy of the order along with the material in his possession referred to in that subsection to the adjudicating authority in a sealed envelope in the manner as may be prescribed, and such adjudicating authority shall keep such order and material for such period as may be prescribed. Every order of attachment made under subsection 1 shall cease to have effect after the expiry of the period specified in that subsection or on the date of the order made under subsection 3 of section 8, whichever is earlier. Nothing in this section shall prevent the person interested in enjoyment of the immobile property attached under subsection 1 from such enjoyment. 5. The director or any other officer which provisionally attach any property under subsection 1 shall, within a period of 30 days from such attachment, file a complaint stating the facts of such attachment before the adjudicating authority. So there are two safeguards here as
The complaint has been filed.
yes. So there are two safeguards. One, my lord, I have to immediately forward the reason to believe. Number one, I have to record reason to believe. Number two, I have to forward it to the adjudicating authority. Number three, I have to file a complaint before the adjudicating authority within 30 days. Now, all these safeguards have been complied with. These are the statutory safeguards which are laid down. I have complied with. Now, Lord, please have a look at what happens under section 8. Once these safeguards are complied, the proceedings move to the office of the adjudicating authority. 8. Adjudication. On receipt of a complaint under subsection 5 of section 5, or application made under section 4 of 17 or subsection 10 of 18, if the adjudicating authority has reason to believe that any person has committed an offense under section 3 or is in possession of proceeds of crime, it may serve a notice of not less than 30 days on such person, calling upon him to indicate the source of his income, earning or assets out of which or by means of which he has acquired the property attached under subsection 1 of section 5, or seized or frozen under 17 or 18, the evidence on which he relies and the other relevant information and particulars, and to show cause why all or any of such property should not be declared to be properties involved in money laundering and confiscated by the government, provided that where a notice under this subsection specifies any property as being held by a person on behalf of another, a copy of such notice shall also be served upon such other person. Then subsection 2, the adjudicating authority, after considering the reply, if any, to the notice issued under subsection 1, hearing the aggrieved person and the director or any other officer authorized by him, so hears both parties, taking into account all relevant materials placed on record before him by an order, record a finding whether all or any of the properties referred to in the notice issued under subsection 1 are involved in money laundering, provided that if the property is claimed by a person other than a person to whom the notice had been issued, such person shall also be given an opportunity of being heard to prove that the property is not involved in money laundering. Where the adjudicating authority decides under subsection 2 that any property is involved in money laundering, he shall, by an order in writing, confirm the attachment of property made under subsection 1 of section 5, or retention of property or record seized and frozen under 17 or 18, and record a finding of fact to that effect, whereupon such attachment or retention or freezing of the seized or frozen property on record shall continue during investigation for a period not exceeding 365 days, or pendency of the proceedings relating to any offense under this act before a court or under the corresponding law of any other country before the competent court of criminal jurisdiction outside India, as the case may be, and become final, alter an order of confiscation is passed under subsection 5 of section 7 of 8 or subsection or section 5(8)(b) or section 2(a) of section 60, where 4, where the provisional order of attachment made under subsection 1 of section 5 has been confirmed under subsection 3, the director or any other officer authorized by him in this behalf shall forthwith take possession of the property attached under section 5 or frozen under subsection 1(a) of section 17 in such manner. The rest may not be relevant. So therefore, my lord, the act, my lord, the validity of this act, particularly these two provisions, were challenged, and in the landmark judgment of Vijay Madan Lal Chaudhary, their lordships have upheld the validity. They particularly emphasize the various safeguards. For instance, I have to record reasons to believe. I have to send immediate.
Is the notice issued under? Notice issued, notice issued under subsection 8, under section 8. Now, giving them an opportunity to explain. Now, my lord, the petitioner, the adjudicator given, he says, please come before me. Please furnish documents to show where did you earn this income from to buy this property. Please satisfy me that this is not proceeds of crime. Not can the petitioner come before your lordship and say, I'm not going to respond to that? They're saying it's by an order of court. Yes, fine. But they can whatever material they have. Now, my lord, coming to the facts of the case, I heard my learned friend say that this is not at all, this has got nothing to do with that complaint. We'll keep that aside for a minute. No, my lord, that is factually incorrect, that statement. I have appeared in the matter in other proceedings as well. The complaint lodged by the complainant is that, my lord, he says, he refers to the 14 sites of the chief minister's wife and says this is only the tip of the iceberg. And then he says there are about 1400 other allotments. Let us see, why do we mix it up with that? No, I am only responding to the submission. If my learned friend has made an incorrect submission, my lord, I am only meeting that incorrect submission. Correct. Yes. That is of no consequence. It's not a part of that. Yes. Though according to you, this may have some similarity in terms of. No, my lord, that is not right. What I am trying to submit before this honorable court is that this is all part of a mega wrong allotment of sites by violating law, scheduled offenses, by committing scheduled offenses. Therefore, my lord, every site becomes a proceeds of crime. If the allotment of the site is by a criminal activity, then, my lord, the site becomes a derivative of that criminal activity, and it satisfies the definition of 2(1)(u). There's no limitation, is it? There is no limitation. No limitation. There is
that has been clarified in Vijay Madan Lal
Yeah.
Chaudhary. The day when they portrayed.
Yeah, we have acted within some 4 days from the date that the scheduled offenses, the FIR was filed. We cannot initiate any proceedings, my lord, until there is a FIR filed in respect to the scheduled offenses. Is there a limitation for taking cognizance or
No,
action?
but in this case, my lord, that would not be an issue because we have acted immediately. From the time of registration of the FIR, we have acted within 4 days.
I'm saying, is there a limitation to take action under the act? Is there any?
No,
schedule?
because no, the very allotment is 2023.
20?
The allotment is 2023.
Resolution is
Which resolution, my lord?
of MUDA to allot sites?
MUDA resolution, the date, my lord, I'll furnish to your lordship. It's not on my fingertips, but the impugned allotment.
21/3/2023, Annexure A.
All right. So, which means the resolution, the allotment, all of that have taken place in 2020. Now, my lord, I have, as an authority who is invested with the power to investigate if a particular property is a proceeds of crime, I have fully complied with sections 5. If I have fully complied with section 5, does it leave any scope for judicial review? Lord, the settled principle is that in the judicial review, your lordship will only see whether I have complied with the safeguards which are contemplated in the section 5. Lord, I have complied. The case of the petitioner is not that I have not complied with any safeguards. I have complied with the safeguard. What are those? Please.
Just one. Now, this is a matter that requires hearing even on the jurisdictional point. Now, you would assert that there is jurisdiction. They would assert there is no jurisdiction. Whether judicial review is to be exercised, I'll hear. I will only say that any action by the respondent would be subject to the outcome of the.
Lord, may make
just
on the,
one.
no, on the interim order.
I have not
Allah,
said.
I want to concede an
I have
interim
not
order.
said anything.
I want to concede an interim order because in connected matters there is already an interim order. My lord, item number 22.2 as well as 22.3 there is an interim order. If your lordships consider granting similar order, my lord, I have no objection.
What is that interim?
My lord, that order, if I may read out.
Yes.
My lord, it says, heard the learned counsel for the petitioner, learned ASGI, appearing for the enforcement directorate, the respondent ED, the adjudicating authority under section 8 of the PMLA is at liberty to proceed further following the show cause notice issued to the petitioner herein and pass appropriate orders in accordance with law after providing an opportunity to the petitioner. Till passing of the final order, the respondent shall not be dispossessed of the sites and the petitioner shall not alienate the sites till the adjudicating authority passes an order under section 8. All contentions of the parties of the petitioner, including the reasons to believe, are kept open. And that writ petition arises from the same PAO, provisional attachment order. It is the very same, absolutely same.
In fact, if I may say so, my opening sentence was, this is not a case of 50-50. That was my opening sentence. It has not been disputed by my learned friend so far. Let him demonstrate where I have been benefited by the 50-50 rule, which is the very foundation for the entire criminal case. There is not even a complaint against us, no FIR against us. All these submissions are totally false.
Similar order.
Repeatedly, the very opening sentence is 50-50.
I have no objection if similar interim protection is given. Not otherwise, my lord, the writ petition is not maintainable. My lord, pending decision on the maintainability, my lord, there cannot be a greater protection than what has already been ordered in other cases.
With great respect, that has no relevance to our case. That is a 50-50 rule case.
50-50 was only one of the
deliberate attempt to club the two.
50-50 was only one of the irregularities. There are
deliberate. That is the opening sentence.
Just one. Now, whether the action taken is one without jurisdiction is what you are contending.
Please.
I will hear you on that.
Yes.
Nevertheless, you could participate there without prejudice to this. That orders to be passed would be subject to the outcome. I'll take it up for here.
They have filed reply to the show cause.
Can I make this request? Participating, no difficulty. Let them not pass any final orders because when they are challenging the jurisdiction, legal lordships would not permit them to pass.
Then participation becomes meaningless.
Season of the matter as to whether there is jurisdiction or not. I just wanted to mention one thing. The sine qua non for the purposes of any right being agitated or adjudicated is the basic application of mind. If I am in a position to demonstrate before your lordships that this is something which is completely lacking with the enforcement directorate, your lordships will have to interfere. Failure of statutory authorities to exercise their mind for the purpose of including these properties is a very grave issue. Property rights cannot be dealt with by them in this manner. This is a constitutionally protected right because whenever such things happens, they may have a due procedure but still have a constitutional right to protect my interest in the property concerned. First thing is they will have to demonstrate their application of mind as to how you included these properties. It is a very simple case. They said 50-50 is a scam. So there is something which is happening. So they wanted to include the properties. Then came the present set of properties. Present set of properties, how it came about? There was a review petition which was filed before the division bench. Muda said that this is the resolution passed by the Muda. We wanted to allot the sites in favor of those persons who had lost the sites when it was a revenue site before the acquisition. That was recorded. Matter went to the Supreme Court, not at the instance of the erstwhile landowners. Supreme Court confirmed the orders passed. Then we came before the contempt court. In the meantime, 50-60 sale deeds were executed pursuant to that resolution which was passed, and on the basis of which the orders which is passed by the review court, confirmed by the Supreme Court and as directed in the contempt court. These materials are very much with them. It is not pertaining to 50-50. It is accommodating minutes at an allotment price. It is not 50-50. At an allotment price, the sites are being given to those persons who are the site losers. We are not the erstwhile landowners. We are the site losers because of the acquisition as revenue site owners. This is the resolution. Whether the resolution is required to be implemented, it's a different question. But where does the ED come from?
And we have paid
Resolution
the,
is not in dispute.
we have,
There is no allegation pertaining to the resolution. Do they want to make an allegation pertaining to the orders passed in the contempt proceedings that these sale deeds will have to be executed in our favor, or the fact that the Supreme Court has confirmed the orders passed by this honorable court in the review petition by imposing a cost of 50,000 rupees on the petitioner therein. This is what has happened.
The review petition was taken up before the apex court.
Yes, it was taken up before the apex court. Apex court confirmed that order by imposing a cost of 50,000 rupees while dismissing the SLP.
Where is that order?
What's the title? What's in WP number 1644?
No, is it just 1 minute?
Annexure C, page 57.
Page
57.
Now, Lords, may kindly see the preamble to this order, Lords, first. Arising out of the impugned final judgment and order dated 19/4/2023 in RP number 135 of 2023.
Which is annexure B.
Which is annexure B, that is the order which we are referring to. We have an extrajudicial exercise.
What is
here.
the apex court order read?
That's page number 54. That's page number 58.
58.
Yes.
Sorry, page 58.
Yes.
The last paragraph. What is stated is that the opposite respondent petitioner in all the above matters is approached the court by challenging the opposite orders passed by the High Court. When he was only a respondent and not but and a petitioner and opponent in many of the cases dismissed by the High Court. We think filing of the special petition is gross abuse of the process of the court, and hence the special petition is dismissed with the cost of 50,000 to be deposited by the petitioner to the registry of this court within a period of 4 weeks from today. On such deposit being made, they shall be transferred to Supreme Court legal services. Then a liberty was reserved for him to seek review minutes in a writ petition which he had filed. Special petition is accordingly dismissed in view of the aforesaid terms. Once his speaking order is passed, the orders in the review petition merges in the orders of the Supreme Court. Muda is a party there.
Who was the petitioner in that matter?
The erstwhile landowner who claimed that he had an interest in the property before the acquisition.
He had challenged the very acquisition proceedings.
State is a party, Muda is a party.
This requires hearing.
This requires hearing.
If the, I'm just asking, I'm just thinking
Yes,
aloud.
Lord, it requires.
If the sale deeds are executed pursuant to orders of court.
No, Lord, my response is this. Lord, I've heard my learned friend. In the review petition, it was only a concession made by the counsel for the Muda. So there is no judicial order. 1 minute, please. Then, my Lord, that is my first submission. Secondly, the illegalities were discovered, particularly pertaining to generation of proceeds of crime. The investigation took place only after these orders were passed. So, in other words, the illegalities, particularly the generation of proceeds of crime, was not available for the benefit of this Honorable Court as well as the Supreme Court. Lord, their lordships have passed an order on the basis of the right made out in that case. But I have discovered, subsequently by investigation, I have got material evidence which points out that the allotment pursuant to their lordship's order is due to a criminal activity. So therefore, my Lord, the passing of the order by lordships either in the review or in the SLP does not come in the way of my exercise of jurisdiction under section 5 and section 8, because this is a subsequent discovery.
Sir, kindly accept that statement
So,
of the learned senior.
Lord,
Are they
my
entitled to sit-
investigation
Are they
commenced.
entitled to
My
sit in
my
judgment over the
investigation
Supreme Court
commenced
order?
only in October
When they sit
2023.
in judgment saying that they have discovered something new.
But I cannot, I started my investigation only after the FIR was filed.
But then, just 1 minute, Ravi Shankar, please. Now, against that order of the Supreme Court, you should have sought for review.
No, why should I seek, Lord?
Because you are contending that the order passed by the apex court is coming in the way of.
No, I have never contended. I have not contended at all.
Documents are made.
In fact, in the contempt, my lord, I was dragged in the contempt petition, and my lord, this honorable court entertained my impleadment, and honorable Supreme Court was pleased to set aside.
You know what happened to the contempt order, contempt proceedings?
My lord, the contempt, my lord,
This
for a
is the-
brief period,
This
I
is
was
the order
impleaded.
passed in the contempt.
For a brief period, I was impleaded
what-
because I have initiated proceedings. I was impleaded in the contempt proceedings. Say on the ground that I am coming in the way of implementation of their lordship's order. Honorable Supreme Court set that aside and gave the liberty to the petitioners to challenge my provisional attachment order, which is why these petitions are filed.
Yes, yes.
So
yes.
therefore, my lord, therefore, the passing of the orders earlier will not come in the way. They have to now show before your lordship that my action is without jurisdiction. My lord, I do not question their right of allotment. My lord, they are land losers. They may be entitled, but my lord, they cannot question my jurisdiction. They cannot say I have got a constitutional right of property. Well, I'm following the procedure established by law. If I have violated section 5 or 8, my lord, they have a case before your lordship. So all that they can show is, of course, my lord, I respect their property right. But if I violated their property right, my lord, kindly step in and show indulgence, my lord. But then the question is, I have not violated any of the safeguards under section 5 or under section 8. And my respectful submission is, in judicial review, your lordship will confine only to verification of the violation of any of the procedural requirements under 5 and 8. Your lordship will not entail a detailed inquiry on the merits of the matter. They have been given an opportunity. All the contentions that they are now raising so vociferously, they can do it before the adjudicating authority. That is what the law contemplates. They cannot convert your lordship's court into an adjudicating authority's court. Your lordships are not deciding a section 8 application. They cannot reduce that, my lord.
No, just one. Now, insofar as their contention that as regards allotment, etc., it's a matter of law. No doubt, direction is passed, allotment is made, even though it may be pursuant to the order of the court. The criminality of action is a separate proceeding that cannot be linked to orders of the court. That is their contention.
Yes, with great respect, short question for consideration is this. Are they entitled to sit in judgment over the order passed by the Honorable Supreme Court, confirming the order passed in review petition? My learned friend is describing it as a concession. Expressly court has directed that Muda shall consider and pass allotment orders on the basis of the resolution.
I have not made any concession.
Just now, my learned friend made a submission. It is based on a concession.
No, but they are contending,
that's your wrong
just
understanding.
1 minute. They are contending that the aspect of criminality ought not to be linked to the orders of the court. And that's a different aspect of inquiry.
There is no predicate offense so far as this allotment process is concerned. The predicate offense which they are alleging is only with reference to 50-50. Why did the ED come into this? For section 5, section 8, whatever they are telling, the sine qua non is application of fine. Can't they look into this paper? This is not 50-50. Let them produce the FIR pertaining to the.
Lord, I have given reasons. Lord, I have given reasons. I have given reasons in the PAO.
Sir, 124, page 124, I showed the opening sentence. This is the very foundation of their case. Yeah. A total of 48 sites have been allotted as compensation under 50-50 scheme. Kindly see 124. Let my learned friend demonstrate the truth of this statement.
I will take this one. Let me take this offer.
Let one whisper anywhere.
Yes.
That
let me take
we
this.
are beneficiaries of a 50-50 rule.
As compensation.
As compensation.
No. They cannot tie me down to some 50-50.
Entire market value has been paid.
They cannot tie me down to 50-50. I will show that the allotment is due to a criminal activity. What? No. That is the law, sir. That is the law, sir. 2-1, you please read. You're not there when I read out.
In that, Yes, let them withdraw and then.
There's no question of withdrawal. My lord, I have exercised my jurisdiction.
Yes, let them substantiate how it is 50-50 rule. That rule was no longer in existence on the day the
reasoning,
sale deeds were
the
executed,
findings,
allotment
my lord,
was made.
findings in respect of the allotment made by the Sangha, my lord, begins at page 124. My learned friend read only 2 lines and stopped there, but that is the actual reasonings run from page 127 onwards until about page 130. My lord, it may take, my lord, we would have to go through that entire one if, my lord,
Up to 137.
if there is time, my lord, I will read it.
124 to 137.
Otherwise, let no final orders be passed, we'll hear. Let them go ahead. You subject yourself, and you subjecting yourself will not be
My lord, then, my
is
lord,
without prejudice to
now, my lord,
contentions.
as of now, pursuant to a
I'm not staying. I'm
no,
not
no,
staying.
pursuant to a show cause notice, reply has been filed. The only thing that needs to be done is to consider and pass an
Then
order.
go ahead, we'll see. I'm not coming in the way. Let the adjudicant authority consider. Let orders not be passed, we'll see. I'll hear. And then
We are ready to address the matter even tomorrow, day after,
since the
any day.
material have already been produced, the only thing that remains is passing of an order.
now, any finding made by me will facilitate, may facilitate investigation also. Jurisdictional point is raised. They are saying that court has no jurisdiction. I mean, authorities could not have initiated. I'll make a ruling on that. That is the only point. I cannot enter into a SIFT and enter into the
True. My lord, therefore, my lord,
material on record.
would your lordship kindly consider passing an order which is similar to the orders passed in connected matters?
No, that I'll see. That I'll see.
Yes. Lord, the connected matter identical.
No, no, they are not identical.
Absolutely
50-50.
identical in the sense
50-50
in
is
respect
the
of,
allegation
my lord,
there.
if there are 4 illegalities and if one of them is 50-50, then, my lord, absence of 50-50 in one does not mean that it is not similar.
That
It
the
is the
whole
common
foundation.
provisional attachment order. Or lordship may call it tomorrow, my lord.
No, I can't. I have a heavy roast.
Allah, I just wanted to take your lordship.
Requires some hearing. Any expression cannot be made unless I hear both of you. But I'll record a finding on
Then,
the
my lord, may I make this request, my lord. Lordship may have it after 1 or 2 weeks. Till then, give the opportunity to the petitioners to go and furnish whatever material they have, whatever submission they have. And before that, my lord, lordship may take this up for hearing, so that your lordship will decide the case before the adjudicating authority.
just wait, Ravi Singh. Learned senior counsels, Shri Ravi Shankar and Shri Abhay Verma Kumar appear for the parties in
Appear in 12449.
And
my learned friend
Ravi
appears
Verma Kumar
in
appears in 12449 of 25. Yes, Ravi Shankar.
16455 of 25.
16455 of 25. It is submitted that notices have been issued under section 8 of the Act
By the
adjudicating authority, and they have challenged the validity of such proceedings.
There is one more appeal.
Raising various contentions, including that allotment was made pursuant to judicial orders, which eventually have culminated in the order of the Apex Court, passed in SLP number
14868 of 23. 868 of 23.
14868 of 23. Learned ESG appearing for the ED,
Yes.
Enforcement Directorate, submits that the aspect of criminality is to be looked at differently and need not be tied down to the civil rights that may have flowed through directions of the court. in light of the jurisdictional issue raised by the petitioners, matter requires consideration. Full stop. The petitioners to make out the response to the notices under section 8. Full stop. However, adjudicating authority not to pass any final orders till the next date. Now, both of you file your synopsis of whatever the legal contentions, what is the scope, etc. And then we'll take it up.
Any day, any
Both
day.
sides
Any day,
to
my
file
learned
their
friend wants.
synopsis of submissions
Yes, sir.
along with
Next
a
week.
list of dates. The scope of inquiry by way of judicial review to be adverted to by both parties in the written submissions to be filed.
Very good.
Relist the matter on
Would 26 suit your lordship? About 10 days away.
We commencing 30th.
All right. No.
2nd of July at 2:30.
I'm sorry?
2nd of July at 2:30.
At 2:30. Very well. I'm grateful.
But you must file your synopsis in advance. I want to have a picture of what is in your mind. Synopsis must be
Lordship may
filed.
say synopsis to be filed by 30th.
Yes.
30th June.
Synopsis to be filed by 30th of June.
May I make one small request?
Yes.
Short indulgence. Matter is set down on 18/6/2025 in Delhi at 2:30 tomorrow. Can we get some breathing time?
That they want some small
Yeah, because
extension.
they will have to appear
Let them
for.
make necessary application by, in the light of this order, they can make necessary
there-
request to the tribunal.
The order is peremptory. It says no adjournment will be. Therefore, a
No, but
short,
then, by
some
virtue
breathing
of this
space.
order, they have to go and participate.
Correct, correct.
They will participate. No, no, no.
The
I'm not
direction is
saying.
only not to pass final order.
No, no, no.
The other processes should go on. So,
No, no, no. I'm
my
not
lord,
saying
so therefore, my lord, that indulgence is not justified.
the indulgence is only for appearance.
And a request is made for extension of time to respond to the section 8 notice. Such a request, if made before the authority, to be considered appropriately, considering that the matter was listed before this court on this day.
I'm grateful.
No, how can it be dealing? No.
Now, arising from the same provisional attachment
Let
order,
us see.
the issue is absolutely the same.
Let us see. When we are hearing.
Some minor factual variation could be there. Otherwise, on a legal principles, they are all the same.
Let us see. When we are hearing it, we will decide.
Handle.
Yes. It will be uploaded.
Yes.
23.
Please, my lord. My lord, I identified the findings in the inquiry report and it also given a memo with the voters list that shows members on 25/2/2022.
Yes, government.
So, your lordship, there was a notice issued on 22/2/2025, calling upon if there is any objections. There was no objections. And based on that calendar of events, we have.
Correct. Now, the submission made by them was specifically that the very inquiry had concluded with some observation.
Okay, yes.
That the amount that was paid in bulk towards membership, there is something on the face of it, whatever. So you take a decision before you go ahead with the election. That was the concluding part of the inquiry report. Only contention is that 1,997 members, whether the entirety of those members are a part of your voters list. If it is not, or you have weeded out, there ends the matter, no question of interference. But they are saying, or the submission made, they filed some memo yesterday, saying that those very same members with respect to whom amounts was collected are a part of the voters list. Is it true?
No, it is only 12 and 1,200 members.
Out of the 1,997,
1,200 have remained.
After verification, we have concluded that 1,200 including 1,200.
And that is the troubling aspect, my lord.
no, just one.
Around 1,200 members, your lordship.
1,200. Now just go to the conclusion of the inquiry report.
Thousand two hundred.
The figure I got was 1,267. So my learned friend is right that it is around 1,200 members who remain on the list.
Now just go to the conclusion of the inquiry report.
On that specific issue, my lords may see page number 217. 217 on the specific issue of the members.
I want to know
Yes.
whether in the report,
please,
there is a finding that after going through everything, the conclusion of the inquiry is that these members are bogus, or the amount that was collected towards the membership is something that should not be taken note of.
Yes.
What is the finding?
I'll just read, my lord. My lords may start at page 216.
16.
My lords will see on page 216, probably in point number 3, about 10 lines down, there is a sentence that starts saying, "E bagge lokayukta." I'll read from there, my lord. "E bagge lokayukta ಕಚೇರಿಯಿಂದ ಪ್ರಾಥಮಿಕ ಪರಿಶೀಲನಾ ಟಿಪ್ಪಣಿ ಪಡೆದು ದೂರುದಾರರು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಟಿಪ್ಪಣಿಯನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ 25/2022 ರಂದು ಸಂಸ್ಥೆಯ ಬನಶಂಕರಿ 2ನೇ ಹಂತದಲ್ಲಿ ಕರ್ನಾಟಕ ಬ್ಯಾಂಕಿನಲ್ಲಿರುವ ಉಳಿತಾಯ ಖಾತೆಗೆ 39 ಲಕ್ಷ ರೂಪಾಯಿ ಜಮಾ ಆಗಿರುತ್ತದೆ ಎಂದು ಮತ್ತು ಈ ಸಂಸ್ಥೆಯ ಕಾರ್ಯದರ್ಶಿಯಾದ ಶ್ರೀ ಕೃಷ್ಣೇಗೌಡರವರು ಖಚಿತಪಡಿಸಿರುತ್ತಾರೆ ಮತ್ತು ದೂರುದಾರರು ಮಾಹಿತಿ ಹಕ್ಕು ಅಧಿನಿಯಮ 2005 ಅಡಿ ಮಾಹಿತಿ ಪಡೆದಾಗ ಜಮಾ ಮಾಡಿದ ವ್ಯಕ್ತಿ ಒಬ್ಬರೇ ಆಗಿದ್ದರೂ 5 ವ್ಯಕ್ತಿಗಳ ಹೆಸರು ನೀಡಿರುತ್ತಾರೆ. ಅವರು ಯಾರೆಂದರೆ ಶ್ರೀ ಕಟ್ಟೇಗೌಡ, ಶ್ರೀ ಮಹೇಶ್, ಶ್ರೀ ರಜತ್, ಶ್ರೀ ಗುಂಡಪ್ಪ, ಶ್ರೀ H.S.T. ಸ್ವಾಮಿ ಎಂದು ಮಾಹಿತಿಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಈ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಚಲನ್ನಲ್ಲಿ ಇರುವ ವಿವರಕ್ಕೂ ಮಾಹಿತಿ ಹಕ್ಕಿನಲ್ಲಿ ನೀಡಿರುವ ಉತ್ತರಕ್ಕೂ ಒಂದಕ್ಕೊಂದು ಸಂಬಂಧ ಇರುವುದಿಲ್ಲ ಎಂದು ಕಂಡುಬರುತ್ತದೆ. ಈ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಪರಿಗಣಿಸಲಾಗಿ ಇದರ ಸಂಬಂಧವಾಗಿ ದಿನಾಂಕ 25/2/2022 ರಂದು ಕಾರ್ಯಕಾರಿ ಸಭೆ ಸೇರಿ ಸದಸ್ಯತ್ವ ಅರ್ಜಿಗಳನ್ನು ಅಂಗೀಕರಿಸಿ ಅನುಮೋದಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಆದರೆ 13/10/2022 ರಂದು ಮತ್ತೊಂದು ಸಭೆ ಸೇರಿ 1997ಕ್ಕೂ ಹೆಚ್ಚು ಅರ್ಜಿಗಳನ್ನು ಮತ್ತೊಮ್ಮೆ ಅಂಗೀಕರಿಸಿರುತ್ತಾರೆ. ಯಾವುದೇ ಸಂಘ ಸಂಸ್ಥೆ ಸಾಮೂಹಿಕ ಸದಸ್ಯತ್ವ ನೀಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಸಮೂಹ ಮಾಧ್ಯಮಗಳ ಪತ್ರಿಕೆ ಹಾಗೂ ಇನ್ನಿತರೆ ಪ್ರಕಟಣೆ ನೀಡಿ ಸದಸ್ಯತ್ವ ನೋಂದಣಿ ಮಾಡುವುದು ಸಾಮಾನ್ಯ ಪ್ರಕ್ರಿಯೆಯಾಗಿರುತ್ತದೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಸಂಘವು ಸದಸ್ಯತ್ವ ಹೊಂದಲು ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆ ನೀಡಿರುವುದು ಕಂಡುಬರುವುದಿಲ್ಲ ಹಾಗೂ ಸಂಘದ ಅಧಿಕೃತ ವೆಬ್ಸೈಟ್ನಲ್ಲಿ ಸದಸ್ಯತ್ವ ನೋಂದಣಿಗಾಗಿ ಪ್ರಕಟಣೆ ನೀಡಿರುವುದು ಸಹ ಕಂಡುಬರುವುದಿಲ್ಲ. ಸಂಘದ ಚುನಾವಣೆ ಬಾಕಿ ಇರುವ ಸಮಯದಲ್ಲಿ ಸದಸ್ಯತ್ವವನ್ನು ಸಾಮೂಹಿಕ ಪ್ರಕಟಣೆ ನೀಡದೆ ಸದಸ್ಯತ್ವ ಶುಲ್ಕವನ್ನು ಸಹ ಇಡಿಗಂಟಿನಲ್ಲಿ ಪಾವತಿಸಿರುವುದು ನಿಯಮ ಬಾಹಿರವಾಗಿರುತ್ತದೆ. ಪಾರದರ್ಶಕತೆ ಹೊಂದದೆ ಸದಸ್ಯತ್ವ ನೀಡಲು ಮಾಡಿರುವ ಪ್ರಕ್ರಿಯೆ ನಿಯಮಾನುಸಾರ ಜರುಗಿರುವುದಿಲ್ಲ ಹಾಗೂ ಸದಸ್ಯತ್ವ ಕುರಿತು ಕಾರ್ಯಕಾರಿ ಸಮಿತಿಯಲ್ಲಿ 2 ಬಾರಿ ಅನುಮೋದನೆ ಸಲ್ಲಿಸಿರುವುದಾಗಿ ಮಾಡಿರುತ್ತದೆ ಹಾಗೂ ಪಾರದರ್ಶಕತೆಯಿಂದ ಕೂಡಿರುವ ನಿಯಮ ಬಾಹಿರವಾಗಿರುವುದು ಎಂಬ ಅಭಿಪ್ರಾಯ.
Now,
yes,
state.
They have taken the position. My lord, I just want to point out one thing, that the bone of contention is one, the deposit of 39 lakh rupees as membership fees for members included on that particular date, which is 25/2/2022.
Now state, the authority has stated that this group membership, you have to follow some procedure. It is not followed. So out of the very same members, if you have 1,200, then it's a matter to be heard. We cannot allow the election to go on till we decide. The very finding by the inquiry officer is when you are going to enroll members in group, you have to follow certain procedures.
Certain procedures.
That has not been followed. So now if out of 1,997, 1,200 you have allowed, then we have to hear. And then elections
No,
can
no,
be
Your
held.
Lordship, now, once the voters list was finalized, there was a notice issued on 22/2/2025.
Whether they respond or not is one matter.
They have not responded. There's no objection.
They may not have objected, but you cannot go beyond your own inquiry report.
Yes.
If it says that group membership enrollment is not in accordance with the procedure, then the entirety of it should have gone. And then you should have advertised it, ask them to register afresh.
Yes, and my lord, a draft voters list has to be published and objections called for with 60 days notice. That is the primary ingredient.
That is a,
That
that
inquiry
procedure
report
we'll
is-
see.
Not that
procedure
inquiry.
we'll see.
Not that
But
inquiry
now
report.
the enrollment of members cannot be in the teeth of the inquiry report, regarding which we'll hear.
Not that inquiry report is still under challenge, not in a.
There is no stay there.
There's no stay.
Kindly see the.
I must, my lord,
He is
before-
contestant, he has contested the election.
Let us see.
He has contested the election, my lord. Not that, my lord, he has contested the election. He has filed his nomination. My lord, one single person coming and he has contested the election.
No. Now the
The election is not over.
The point, the election.
No, my lord, my ground, my lord, I must.
You lordship may make it subject to the result of writ petition.
No,
For this reason.
absolutely
No,
not,
for
my lord, this cannot.
Because the.
My lord, the impleading applicant has no locus.
Welcome division
just
elections are already being held.
You exclude this 1,200 and you go ahead.
Kalburgi division and welcome
No.
division election have been held.
My lords may hear the
Now,
matter.
Division is left out, it is on 22nd.
Then so
My
far
lords
as
may hear
Bangalore
that.
division,
22nd, my lord.
in so far Bangalore division, until
Like voter list cannot be, my lord, now deleted.
then
now
we have to-
My lord,
Then
we have
already
to
2 plus.
my lord, the impleading applicant is the one the report finds
The
fault
local study
with.
of the petitioner, my lord, he is contested the election. Not that he has not contested
There
and
can
then he has
be-
filed a
there
writ petition.
can be no voter.
My lord, the impleading applicant is
Just
found
1
guilty.
minute.
My apologies.
There can be no voter enrolled contrary to the finding in the inquiry committee. If the inquiry report says that this group members is not followed the procedure, then it has to be redone and there. So you exclude that and let the election be done. There ends the matter without entering into
It
the.
is done by the administrator and the government official. It is not done by the
Correct.
committee.
So that's wrong.
It is not done by the committee, my lord.
The administrative
From
committee.
2023 administrator is there. Not one other reason, but this is the third time
So
election.
let election be held.
This is the third time
keeping us.
election is getting postponed
No, let it.
by a single man.
Let it. No, that's a different matter. If it's wrong, it's wrong. Now let.
Kindly see his conduct, my lord. He has filed his nomination paper. He
Yes,
has contested the election.
Now,
When he has contested the election, my lord, he is not objecting for the voter list. He is only taking a chance, my lord.
Something,
Your lordship,
something against the law cannot be
He is
permitted to
taking a
go.
chance in the court, my lord.
As long as the inquiry report remains, there can be no election, including those members whose membership was a part of the inquiry report. You redo it, you exclude, and then you continue.
ಎರಡು ಕಡೆ ಆಲ್ರೆಡಿ ಎಲೆಕ್ಷನ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ ಎಲೆಕ್ಷನ್ ಪ್ರೊಸೆಸ್ ಕಮೆಂಟ್ಸ್ ಆಗಿದೆ not your lordship may make it subject to the result of
No, your lordship, I'll keep the election officer present. I will just see if those names are
Find
included.
out.
I'll find out tomorrow.
Find out. Tomorrow. Release the matter tomorrow.
Not my impleading application is there.
My lord, I
Filed it. ಅಲ್ಲ ನೆನ್ನೆ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. Let it be put up.
Put up agilva?
Put up ಆಗಿಲ್ಲ.
Impleading application filed on behalf of impleading applicants by Land Council Devi Prasad Shetty to be put up. Yes. You make a one-page write-up of the list of events.
Please, oblige.
Now, in the event, there's no overlap, and you can show.
No, I'll verify if there is any.
You verify.
I'll verify.
If there is no overlap and they are fresh members, then I don't intend to interview.
Very well.
Otherwise, you take a decision. Now he's saying that for so many years, so if at all there is a overlap, then immediately exclude it. If you are ready to take such a decision, I'll pass direction to rehold the election immediately.
Please.
24? 24 Amanda?
Lord, the petitioner, my lord, is an
Canara Bank.
MSME entity Lord, 4 loan facilities were taken. Lord, repayments are being done regularly. Now, my Lord, if it is an MSME entity, they can't.
Canara Bank, who's there? Now, have you raised that at what stage?
My Lord, when 13.2 was, my Lord, given, classifying my account as an NPA, immediately, my Lord, I raise it. I give payments, my Lord, which I am doing for the last 2 years.
Now, what does that Supreme Court judgment say at what stage? It must be raised?
My Lord, it's time when.
Huh?
Lord, in the Proceedings versus board directors of Canara Bank.
Oh, MS.
Lord, what it happened, Lord, they have to give a request, Lord, to the the authorized officer. Lord, the authorized officer should Lord, consider that, and Lord, that Lord, they have to place before the committee.
Yes.
Lord, here I don't know whether Lord, they placed in a request and all. However, I'll take an instruction, have it tomorrow or day after tomorrow. I'll take instruction, I'll make submission. Lord, for that certain criteria, Lord, in fact, even though Lord, in the pro-unit judgments, the unit should run. There are certain criteria, Lord, to fulfill, Lord.
Oh, correct. Now that's a different matter. But the authorized officer must apply his mind.
Please,
If
my
it is raised at the earliest.
Initial stage, please, my Lord.
Correct. That's what even the apex court.
Please, my Lord.
So at what point his objection is raised?
Immediately, my Lord, 13.2 is given. I say it is not even an NPA because I am making periodic payments. Even along with the writ petition, my Lord, I have annexed the statements where, my Lord, payments are made even up to date.
No, that's one part of it.
Yes, my Lord.
But if he has raised it in the initial stage of the 13 proceeding, then the authorized officer must pass some order on that. Either you say.
It's a request for, my Lord, regularization or restructure. If the request,
No.
As per the pro-unit.
Correct. Once they raise saying MSME, then that procedure has to be followed, isn't it? So if he has raised it at 13.2, then the authorized officer cannot ignore it.
This is true, my Lord. The request should be, my Lord, for regularization or, my Lord, restructure. If, my Lord, some contention taken by the borrower saying that, my Lord, I am not defaulted, I am no need to pay.
So
any
that's
money.
a different
That
matter.
is different.
That's a
Here I have to see, my Lord, whether the request is for, my Lord, with the, my Lord, with the pro-unit. The Honorable Supreme Court in the Apex Court in the pro-unit versus board directors of Canara Bank. In that, my Lord, there is a specific request from the, my Lord, borrower to restructure. Then, my Lord, the Honorable Supreme Court said that yes, bank has to.
Once he makes a request saying that I am entitled for benefits of MSME, whatever. So irrespective of the form, then they have to avail him whatever benefit that you find out. Vignesh Shetty accepts notice for response 1 to 3. This is the matter in the preliminary hearing list on?
Within 1 week, I'll take instruction. Within 1 week.
Directive is now, my Lord, they want to sell the gold. Let them not sell the gold, my Lord, because they have got the gold, my Lord. There are 2 gold loans. My Lord, the tenure of the gold loan expires only in August 2025. My Lord, they want to sell the gold immediately, my Lord. Let them not sell the gold. I have produced the, my Lord, relevant documents. My Lords were to kindly take, my Lord, page number 27, 26.
I'll have it tomorrow. Prima facie, you just say on the interim prayer. Vignesh Shetty accepts notice of the respondent. Relist the matter tomorrow in the preliminary hearing list. Only on the interim prayer.
Grateful.
Yes.
This to preliminary matter, serial number 6, Srinivas.
Petitioner, my lord.
Respondent number 1, my lord.
For respondent 6, Your Honor. From our bank, it was informed, Your Honor, the matter has been settled through the builders, Your Honor, in this matter.
You appear for?
Respondent 6.
Who is R6? Who is
R6?
R6
is the builder. R6 is the bank, my lord.
Bank.
Bank.
So it has been settled.
Settled through the builder itself.
Builder. So then nothing survives.
My lord, may I make one submission, my lord? They have given me a no due certificate, but none of it was intimated to me till today, until this was handed over. But unfortunately, my lord, all my original documents, which was handed over at the time of obtaining the loan, is still with the bank.
Correct.
It may be directed, my lord, to be handed over here. I will say I will withdraw my petition itself on the next date.
A week time to be granted.
Find out. Counsel appearing for R6 submits that the dues under the loan account have been cleared by the developer. Such
Yes.
submission is made upon instructions. Counsel for the petitioner submits, in light of closure of loan account, the security and collateral furnished requires to be discharged and documents handed over.
The title deeds more specifically, my lord.
title
It is
deeds-
MOTD.
The title deeds offered as security are required to be returned for say of the bank. Relist the matter on
You get the clarification from the bank once.
when do you want it, madam? First of July.
Great, Your Honor.
1st of July. Yes, next.
Much
Seven,
obliged.
Vinod Kumar M, connected matters, 7.
We are for one of the, representing one of the impleading applicants. my
This
lord.
is all, my lord, food and civil supply matters.
Yes.
Similar tender, my lord, floated across the state. Lot of challenge, my lord, to certain clauses. Now, my lord, I'll have to make a synopsis of all these 22 matters. Your lordship may fix a date. Have it at 2:30, my lord. We'll dispose of each one of them.
Please, my lord, challenge is only to one clause, my lords.
No, file synopsis.
Please, my lord.
File your-
Petitioner, my lord.
File your synopsis. I'll fix a date
My lord, because,
and we'll hear the matter.
I humbly pray that the matter be taken up with at the earliest date possible, my lords, with kind permission, my lords. Because they are the beneficiaries of petitioners of the some interim orders, my lords. Because
Let
of
us
that,
see. Let
I'll
us
have to place, my lord, I'll
Both
have to place
sides.
records, my lord, in all these cases.
Both sides to file their synopsis with the list of dates and summary of legal contentions.
may I humbly pray, my lords, IA2 impleading application is filed, my lords. Because
Just
we are
one minute.
successful.
Just
Please,
wait.
please, I'm sorry.
Generic order pass.
Relist
Generic
on.
order pass. Nothing.
ಅದು ಎರಡೂವರೆ ಕೇಳ್ತೀನಿ ಅದು ಯಾವತ್ತು ಹಾಕಿದ್ದೀವಿ ಅಲ್ಲ ಅದೇ ಯಾವತ್ತು ಬೆಳಿಗ್ಗೆ ಇದ್ದಿದ್ದು ಅಲ್ಲ ಬೆಳಿಗ್ಗೆ ಇದ್ದಿದ್ದು ಯಾವತ್ತಿಗೆ ಹೋಗಿರೋದು 2nd of July 7th of July at 2:30.
Please, my lord.
As far as 7.14 is concerned, I am withdrawing that writ petition. I am for appear for petitioners. 7.14, filing a memo.
7.14 petition is
My lord,
dismissed.
of course, only 7.3 we are for the impleading applicants. I do not know about my learned friend, my 7.1. But the
Allah,
problem is-
1.4,
Just
1.4, sir.
One problem may arise, my lord.
7.14.
1.4, sir.
1.4, I thought.
He's withdrawing his writ
So the
petition.
EPDs, my lord, some allotments are made pursuant to the interim orders.
Allah,
If it is so,
ಅದಕ್ಕದಲ್ಲ.
I don't know. If it is so.
No, that will get washed away.
We should say, my
That
lord,
will get,
attain finality ಅಂತ ಹೇಳ್ಬಾರ್ದು ಅಂತ.
No,
ಇಲ್ಲ
no.
ಇಲ್ಲ ಅದಕ್ಕೇನಿಲ್ಲ.
ಇದು ನಮ್ಮ ಕೇಸ್ಗೆ ಕ್ರಾಶ ಸಂಬಂಧ ಇಲ್ಲ ಅಂತ.
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ.
exam is taken, writ petition is dismissed, student still completes and memo for
7.14.
withdrawal is filed
Anti-transport.
in WP 33933 of 2025. Memo reads as here under.
7.14.
In light of the memo and submission made, petition is dismissed as withdrawn. Needless to state, by virtue of withdrawal of the writ petition, it is deemed that the petitioner's legal grievance cannot be adjudicated upon.
And they cannot be beneficiary of interim orders, my lord.
ಅಲ್ಲ ಅದಿಲ್ಲ ಇವರು unnecessary ಅಲ್ಲ
Interim order stands discharged.
Please, we are more posted.
one more submission, my lord, in point 7.12, my lord, an interim order was granted to open the financial bid. I appear for petitioner. Instead of R, direction was issued to R2, my lord, instead of R1. That correction may be ordered.
No. Now, what has happened to the, what is the stage
Financial
now?
bid.
Just, what is the stage?
Some of them, my lord, work orders are yet to be issued. We await the orders of this court, my lord, to issue those work orders. In some of those cases. In some of the cases, my lord, they've been awarded. And we'll have to update, my lord, and inform the court that work orders have been
Let us see.
22 matters, my lord, I'll have to make a synopsis.
Yeah, make it.
This is regarding opening of financial bid, my lord. Order
Correct.
was
Now-
granted
now that
instead of R2.
That modification will have to be made by the same court which passed the order. I cannot do that. I reserve you liberty. In 7.12, petitioner claims that there is a mistake in the interim order. It's open to the petitioner to seek for clarification before the appropriate bench. Huh?
Date fix ಮಾಡಿರ್ತಾರಾ?
Okay, I'll just find out. On the next date, we'll see what is to be done. I'll clarify that on the next date. Let us see. Yes. Yes.
ಏನಾಗಿತ್ತು?
7th.
Yes.
Serial number 9, my lord.
Yes.
Liberty may be granted to approach the DRT, my lord.
Yes, Vignesh. You appear. You appear.
Vignesh Shetty.
Kodi. The petitioner. No, he wants to go back to the DRT.
Sale is also confirmed. Sale is also confirmed.
Let us see. Petitioner has called in question the validity of e-auction conducted on 30th May 2025. Various contentions have been raised. By the petitioner, including that valuation is not made as per procedure prescribed under Rule 8 within bracket 5 of the rules, as well as procedure of publication regarding auction notice. Certain other contentions have been raised as well. Next, learned counsel Sri Vijay Kumar, appearing for the respondent bank, would submit that during the pendency of the petition, the e-auction is completed and the successful bidder has been issued with sale certificate.
Yes, sir. Option is confirmed.
Auction is confirmed. Auction is confirmed. Full stop. It's further submitted that petitioner is required to approach the DRT if at all any grievance, legal grievance subsists. Next, learned counsel for the petitioner submits that he may be relegated to avail of a substantive remedy. Notice the order of the apex court in Union Bank of India versus Satyavati Tandon and others, 2010 8 SCC 110. In light of the submission made on behalf of the petitioner that he intends to avail of substantive remedy, petition is disposed of without adjudicating on merits. All contentions are kept open. Time spent before this court may be taken note of when the in the event petitioner seeks to invoke substantive remedy before the DRT in an appropriate manner. Accordingly, petition is disposed of.
For petitioner, my lords, the respondent number 3 issued e-tender against the government notification. My lords, kindly see the annexure D, page number 66. My lords.
Page
66, my lords. Annexure D, my lords.
Page
66. Annexure D, my lords.
Correct. So what is your contention now?
Contention, my lords, the petitioner is a fisherman cooperative society, my lords. The notification clearly stated that, my lords, the ಸಣ್ಣ ಕೆರೆಗಳನ್ನು ಗ್ರಾಮ ಪಂಚಾಯತಿಯ ಮಟ್ಟದಲ್ಲಿ ಮೀನುಗಾರರ ಸಹಕಾರ ಸಂಘ ಮೀನುಗಾರ ಸ್ವಸಹಾಯ ಗುಂಪುಗಳಿಗೆ ಆದ್ಯತೆ ಮೇರೆಗೆ ಗುತ್ತಿಗೆ ನೀಡತಕ್ಕದ್ದು. Now the tender has been called for public, my lords.
Just have a look at this order. If this covers, I've considered the priority and then directed them to redo it on same contention. If same order is to be passed, I'll pass it.
Please
make submission by 2:30.
Please
pass over. Copy.
11, Balraj.
My lord, happy for the petitioner, my lord.
Yes.
Senior citizen matter, my lord.
my lord, by third respondent, my lord, by playing fraud, my lord, obtained a gift deed from the petitioner. And my lord, petitioner challenged the same before approaching the assistant commissioner. Assistant commissioner, my lord, passed an order setting aside the gift deed. Against that, my lord, an appeal was filed, my lord, by the relative before the deputy commissioner. My lord, my submission is, my lord, section 16, my lord, appeal is not maintainable. My lord, the division bench of this honorable court, my lord, as held, my lord, section 16 is not applicable insofar as the parent, in pair of the children or the relative. This is covered, my lord.
No, it's only in appeal that this order was modified.
Modified, my lord. The assistant commissioner passed an order in favor of the petitioner, my lord, and set aside the gift deed. And my lord, appeal was
Counsel for the petitioner submits that the order passed by the Deputy Commissioner at Annexure J.
Please, my lord.
Is requires to be set aside on the sole ground that appeal before the Deputy Commissioner cannot be at the instance of
by the beneficiary.
Children, my lord. By the
children or relative.
By the children or relatives, and relies on the order passed in WA 254 of 2024. Light of the same, there would be stay of the order at Annexure J.
Let them maintain status quo
Annexure J.
right now.
Parties
Because
to
the gift
maintain-
deed has been cancelled. Now again another alienation will happen.
My lord, I am
If
in possession
your
of the
lordship
property.
stays the order, then my
stay
lord, they may take advantage of the assistant commissioner's
Stay
order.
of-
Let there be a status quo order. Let some maintenance be granted.
Stay of order at Annexure J, both parties to maintain status quo as on date. He's the senior citizen.
He's the senior
Senior
citizen.
Let us
The
see.
assistant commissioner's order is in his favor.
Let us
The
see.
gift deed has been cancelled there.
Let us see.
Yes.
AG accepts notice respondent 1 and 2. Emergent notice to third respondent. List the matter in preliminary hearing list on week after next date code. Petitioner is at liberty to take out notice to the third respondent by way of hand summons as well. Up to you.
Serial number
And Xerox
96,
medical.
pronouncement of order, serial number 96, Gautam.
And the Xerox medical. Good.
Pronouncement 96.
In light of the above, communications at Annexure W and X are partially set aside with further direction to the Deputy Commissioner Mangalore to pass an order of regularization forthwith in light of the discussion and observations made above. Accordingly, petition is disposed of.
Obliged, man.
Pronouncement, sir.
My lord.
Mentioning at 2:30. 2:30.
My lord.
Huh? What is the urgency?
Nandini Milk Food Parlor, my lord, is ordered to be closed. On the road, my lord, I have been arrears. I don't have.
Tomorrow.
It has been closed, my lord.
Tomorrow we'll have.
Products, my lord, is being wasted.
My lords,
Tomorrow it will be taken up in fresh matters list.
my lords, item number 20, my lords, item
2:30,
21 in the
Only-
second
only-
list.
Only posting, all other mentioning at 2:30.
My lords, item number 21 in the
Mentioning, all
orders
mentioning,
list.
all mentioning at 2:30. Yes. Nalitho.
Your lordships, item number 21 in the orders list, will it be taken up today, your lordships?
Sir, ತಗೊಂಡ್ಬಿಡಿ ನೀವು. ಯಾವ್ದು ಮೆಮೋ ಸರ್? ಫೋಟೋ. ನೀವೇ ಕೊಟ್ಬಿಡಿ ತಗೊಂಡೋಗಿ ಸರ್.
Orders will be taken up today.
ಇಲ್ಲಿ ತಗೊಳ್ಳಿ ಸರ್. ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್ ನನಗೆ ಕೇಳ್ಬಿಟ್ಟು 94 ಬಂದಿಲ್ಲ ಇನ್ನ.
Sir, 61.
24. ಒಂದು ನಿಮಿಷ ಸರ್ ಜೋಡಿಸ್ಕೊಬಿಟ್ಟಿದ್ದೀನಿ ಫೈಲೇ ನೋಡಿಲ್ಲ ಒಂದು ನಿಮಿಷ ಸರ್ ಫೈಲ್ ಜೋಡಿಸ್ಕೊಂಡಿಲ್ಲ ಸರ್ ಒಂದು ಸೆಕೆಂಡು ನನ್ನ ಫೈಲ್ ಜೋಡಿಸ್ಕೋಬೇಕು ಒಂದು ನಿಮಿಷ ಇಲ್ಲ ಅಂದ್ರೆ ಯಾವ್ದು ಕರಿಬೇಕು ಗೊತ್ತಾಗಲ್ಲ ಹಾಂ ಕರಿಯಲ್ಲ ಮೇಡಮ್ ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ಕರಿಯಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಕಳಿಸ್ಕೊಡ್ತೀವಿ ಬ್ರಾಂಚಿಗೆ ನಾಳೆ ಕಳಿಸ್ತೀವಿ ಕಂಪ್ಲೇಂಟ್ಗೆಲ್ಲ ನಾಳೆ ಕಳಿಸ್ಕೊಡ್ತೀವಿ ಇಲ್ಲ ಸರ್ ಅವರೇ ನಾವು ಏನು ಮಾಡಂಗಿಲ್ಲ ಇನ್ನು ನಮ್ಮ ಕತೆ ಕೇಳಿ ನೋಡೋಣ ನೋಡೋಣ ಇನ್ನೂ ಇದೆ ಇಷ್ಟೆಲ್ಲ ಆನ್ಲೈನ್ ಲಿಸ್ಟ್ ಅಪ್ಡೇಟ್ ಮಾಡೋಣ ಅದೇ ಕೇಳ್ತಾರೆ ತಾಳಪ್ಪ ಒಂದು ನಿಮಿಷ ಫೈಲ್ ನೋಡ್ಕೊಳ್ಳೋ ತಾಳಪ್ಪ ಹೌದೌದು ಹೌದು
Good afternoon, Your Lordship.
Yes, good afternoon.
Serial number 94, cast list 1, Your Lordship, since it is not likely to reach the board, would you kindly give a date of 23rd Monday, Your Lordship?
23rd.
23rd Monday, Your Lordship.
Yes.
As advised by Your Lordship, I will also move IE for early hearing, Your Lordship, since it already.
My Lordship,
700 for further hearing. Hong Kong. 230.
230.
Posted at 230 for further hearing. In fact, our written submissions are ready. My Lord speak to the matter, but I call the seriousness to be ready the matter.
You're ready. Just wait, let us see.
My Lordship, CL number 62, my Lordship. Criminal RP. Seek short adjournment, my Lord. 62.1, my Lord.
62.1.
List number 1, my Lord. Seek an adjournment in this.
I'll adjourn again.
We'll file up.
Next week.
Kindly fix a date.
Serial number 85. Serial number 82, my Lordship, for reporting settlement. Few of the petitioners are not present. Few of the petitioners are not present today for reporting the settlement. Kindly have it on Tuesday, or coming Tuesday.
You're correct. Settlement means you must talk to each other, not to the court. You settle it.
Tuesday.
No, correct. Both of you decide and give the date to the court. List the matter on. There must be settlement even in adjournment. Yes, next.
Serial number 85.
First of July.
28th of this month, right?
82 first of July.
Huh?
Semiconductor.
85.
28th of this month.
No, just note date.
20th ಎಲ್ಲ ಇದಾಗಿದೆ ಸರ್. 30th
Here date.
First of July.
1st of July. Yes.
81 will not 81.
81.
81. I'm for responding.
Yes.
Any date will not after week.
Sorry, after relist on.
Any date of July.
81.
2nd of July. ಇಲ್ಲ.
ಆಯ್ತು list in preliminary. I can't pass order in warning list, but I'll fix a date. List the matter.
Mine 81.
Preliminary hearing list on.
Warning list.
Just 1 minute. ಅದು preliminary hearing list ಅಲ್ಲಿ date ಕೊಡು.
81. Any date.
81 I've told.
Please.
Yes.
Serial number 54, my lords, warning.
No, warning list, you at 3:30 you come and you mention. Warning list, you come at 3:30 and mention. Yes. 80? Huh. Huh. Huh.
So next week date ಕೊಡಲ್ಲ ಸರ್.
89. Interim order in operation. 89. Interim order in operation is extended. List week after next. It's a bank matter.
Bank matter. A loan, I obtained the loan, I paid entire loan amount, and they have fixed, unilaterally altered the terms and conditions of the order, fixing instead of 240 months, 296 months. And after considering the documents I have produced, this honorable court was pleased to grant interim order.
8th of July.
List
Yes.
number 2, my lord.
Yeah.
Serial number 26. This was that matter relating to that road to the mining area.
No, this is not the road. This is the cutting of trees.
Correct.
This number?
Cutting of trees.
They filed an application.
Serial number?
26.
In Narayan.
Cutting of trees in that mining area, my lord, because that has nothing to do with respect to the CA land, my lord, which I had to give the additional CA land, and therefore we had made an application, my lord, to allow us to cut trees in the mining area, not outside. The forest area which we had compensated, that is separately given. Now on that there's a dispute as to whether or not it is CA land or not. But compensatory afforestation, and my humble submission, can't come in the way of clearing trees within the mining area to carry out the mining activities. That is why we had made that application.
No, the application is filed. Your lordship will have to file objections to that.
Find out and take complete your instructions. If it's permissible, you impose onerous condition. Let them do more social forestry. That would be the nature of condition. As long as it is permissible. If it's not permissible, you take your stand.
No, the only stand that they've taken is because CA, compensatory afforestation, is not done. Therefore, we will not permit. According to them. According to us, it's been done, accepted, sale deed executed, all of it done.
Okay, next week we'll give a date and then we'll see. Complete instructions by then.
Yeah.
Relist on.
It will be Monday, my lord.
24th.
24th.
Yes.
Lord's interim order earlier granted.
Interim order in operation is extended till the next date.
The leave of the court.
It's a more small minor objection is there. If the file is given, I will rectify that. Now it's.
With the leave of the court, I told my friend made a mention, the power supply has been cut off to the stadium. There's a serious effect. I understand the court is rising at 3. Can we take a chance at the end of the list?
Tomorrow.
But till then, the problem is no notice and water will stagnate because sub-air system, if it rains, that is one difficulty which if it doesn't rain, the entire...
No, correct. I may not be able to hear the others also. That's why I had it tomorrow. The court is crowded. There are some other...
I understand. That's why I'm making a request if to be done because 6,000 members we have and even that if there is no power, everything will be...
You take.
I'll take my chance.
Take a chance.
Yes.
If I
yes.
have time, because without hearing, I will not.
Yeah,
pass
I
it.
know. I understand.
Yeah,
Grateful.
End of the list. Yes.
My lords, one humble submission, my lords.
Yes.
My lords, in serial number 93, cause list 1, my lords.
Yes.
My lords, this honorable court had ordered to serve the notice on the opposite counsel, my lords. The notice has been served, my lords.
Yes. It's
My
a
lords, in
fresh
this
matter.
fresh matter, my lords.
Then we'll have it in fresh matters list. I'll give you a short date. It
My
won't
lords,
reach
one
at
humble
93. Tell me.
My lords,
Tell me.
we are ready to pay the outstanding. They have freezed our account, my lords. We do not have any alternative account to pay it, my lords.
Correct. List the matter in the preliminary hearing list on 93. 93 list 1 short date. Yes.
My lords, if I may make a mention of serial number 92, it's a fresh matter, my lords. On the last date also it was adjourned and today's date was given. My lords, my urgency is that I am the participant in a tender whose bid was rejected without assigning any reasons. My lords, my only humble request is that a date may be assigned to us so that the matter will be taken up.
List the matter in the preliminary fresh matter. Interim
Yes, my
order
lord,
is not
it's
yet
fresh matter.
considered. List the matter in the preliminary hearing list on 20.
23 serial number 23.
92. On 23rd in the preliminary hearing list. Yes.
Lords, date was not given in for serial number 93, my lords.
93.
23/6. Pass our matters. List 1. Serial number 10. Somshekar Naidu. Serial number 10. Somshekar Naidu.
Action purchaser.
EP1 it is mentioned.
Huh?
EP1 the website council informed it is mentioned.
Mentioned for 81.
27. I don't propose adjournment, but any short date may be
27.
Today, but the possibility of reaching
81 short date vacancy.
27.
Second.
10.
List is full. List is full. We can't help it. Yes.
10. Somshekar Naidu. Vignesh
Sale
Shetty.
taken place. Confirmation of the sale. Calling and they are telling that he has just.
Yeah. Counsel, in surfacey, you are good for me. In surfacey matters, you are the best advocate in front of the bench. I'll give you better relief than otherwise. Now you tell me what the matter is, we'll see. You tell me the facts at least. Let us see. What is the matter, we'll see.
Mortgage 2 properties, your lordship.
Could it? Yes. Then what happened?
From the COVID time, I was unable to pay my EMIs, your lordship, my loan. My accounts have been terminated as NPA, your lordship. After that, I have paid 10 lakhs to get my account regularized, your lordship. In the meantime, bank has issued a sales certificate, your lordship. That, through my late petition, I have got that stay, and my whole exercise here was that preliminarily I tried that one property on which they had initiated sales.
Just turn the mic to your side. Turn the mic to your side. Yes, yes.
One property.
Look here, counsel.
Please, your lordship.
I will not damage. You tell me what it is. I'll whatever relief possible, I will do it. Tell me.
Please, your lordship. In my.
Then it was regularized.
It was not regularized. It was not regularized even after paying 10 lakhs. Then from that day, I have made an affidavit undertaking that I shall pay it in 4 lakhs. But then the preceding judge, lordship had taken in the view that the sales certificate which was issued was undervaluated and it was written, and they had given me an opportunity to settle the matter. And my whole and sole intention was to settle the matter. As of today, I am due of 1,49 lakhs. And that also my party is not trying to shy away. And I am ready to pay the entire amount. And now this 1,49 lakhs which they are claiming is amalgamation of 3 accounts, your lordship. That is one property under which now present sale certificate has been issued. The second property, which is in Malleshwaram, which has been amalgamated, my two
So
petitioners,
there were 3 loan accounts.
three, and third is my car loan account.
So all the 3 they've clubbed.
They have clubbed, and they've asked
They're
me
saying
to
that you settle
all
all the 3.
three, then the account shall be closed and my documents shall be relieved.
All the 3, the due is 1.49.
1 crore 49 lakhs,
Yes.
please, your lordship.
Now have they conducted auction? Not yet.
They have conducted auction, they have got an auction purchaser. Sale certificate has been stayed due to the interim orders passed by this, in this writ, your lordship.
Yes.
Kindly come to page number 6, prayer, but thought before this on report. Set aside the sale notice dated 23/8/2024, issued by the respondent bank. That is set under page number 9. Lord, we have conducted the auction. We issued a sale notice on my lord. We have conducted the auction on my lord 13. Lord, kindly come to my lord 13/9/2024. 13/9/2024. Subsequent, my lord, in fact, my lord, respondent number 2, my lord, my lord, he arrayed as a my lord successful bidder. He paid the 25% of the money, my lord. We have issued a sale confirmation. In fact, my lord, after that, my lord, on 24/9/2024, the petitioner, my lord, approached this honorable court, made a submission that I am ready to pay entire money. This honorable court shown certain indulgence, and my lord granted an interim order saying that not issue the sales certificate in favor of my lord auction purchaser. My lord, on 17/4/2025, this honorable court passed an order. My lord, kindly see the order passed on 17/4. Petition should repay the entire outstanding along with the up-to-date interest and expenses and 10% solution to the auction purchaser on or before 2/6/2025.
Order dated
17/4/2025. In fact, interim order granted on 24/9/2024. That time, my lord, sale confirmation is completed. My lord, sale is completed. Sale confirmation issued. Sale certificate yet to be issued. That's the only, my lord, my lord, in fact, my lord, 17/4/2025 order also is not complied. Thereafter, my lord, this matter listed before the honorable court twice or thrice. Every time they made a submission.
So till by 2/6 they were required to pay the entirety plus 10%
to
solution.
the auction purchase. Some arrangement made with my lord, this honorable court. However, my lord, either they are not paid. My respective submissions are, one is, my lord, the sale is aside. There is, my lord, as my lord, there is an alternate remedy under section 17. Now, my lord, second submission, my lord, the sale is, my lord, already taken place. Sale confirmation is issued. In view of, my lord, Bapna, my lord, I may not in the position to, my lord, the redemption, my lord, under section 13, my lord, we lost. Therefore, my lord, in fact, this honorable court shown, my lord, 3 occasions after passing an interim order on 17/4/2025, 3 occasions the matter was listed before this honorable court. Every time they made a submissions, we are ready and ready. No point of time they came with the money.
Correct. Now you will have to go to the DRT and challenge whatever you want, including the validity of the auction proceedings. I can't here sit and decide on any of your contentions raised.
My only sole request here, your lordship, is I have my party is also not shying away to pay the amount.
Now it's too late now. Now already there's a sale, auction is confirmed. So if at all you want to challenge the validity of the auction, that there was no notice, no procedure followed, you go before the DRT and then you solve it.
Your lordship, my only humble request is I want to settle the matter. I want to pay it.
But now I can't unless the bank wants.
If one day indulgence is given, I shall make good. I will present the DDs one day, your lordship. Now I have to start the whole exercise. My intention is to settle and get my property out of this.
Correct, but how many days he will wait? Every day, tomorrow afternoon.
I understand my brother's difficulty.
Your anxiety is not shared by our client.
The action is conducted on 13/9/2024, my lord. I am deposited 73 lakhs, 25% of amount. Because of this interim order, my lord.
Money he gave to bank twice. We are not able to receive it because of the interim order.
Tell me fast. Tell me.
If it is given one day opportunity, your lordship, I myself will examine it and make sure it is paid. If not, your lordship can take a decision.
Correct. The payment requires that you have to take care of the interest of the auction purchase.
The interest also, your lordship, in the court, it was ordered that 10% solution to be paid. Including that is 1 crore 49 lakhs, which they have.
My outstanding is 1 crore 49 lakh odd, which I indicated.
Plus solution he has to pay.
Separately has.
He has to pay.
That will also, I will make good of that also, your lordship. I will not shy away.
Tomorrow only. Tomorrow, not
Please,
yet.
Your-
And you must only appear. I am not going to
I shall
allow,
not shy away.
I am not going to allow anybody else
No,
to
I
appear.
shall not shy away, Your Lordship. I shall myself be present before.
Tomorrow in the preliminary hearing list.
Much obliged. Your Lordship.
Obliged.
Serial number 13.
I appear on behalf of bank, my lordship, respondent.
Yes.
File my affidavit, which is for 4 weeks, which has discussed.
Yes,
My
madam.
lordship, my lordship, as per the instruction that I have received, if they are ready to pay within 4 weeks the entire amount, we are ready to go with the settlement, my lordship. But it
Yes.
should be within 4 weeks and the entire amount, my lordship.
A copy of the affidavit to them also.
Where is your
They-
affidavit?
We have received.
Affidavit. Yeah. There. Para 7 of the affidavit.
Indeed.
Para 7 of the affidavit.
Yes, my lordship.
So I'll record this then. If this is agreeable, I'll record.
It is agreeable, my lordship, but the one confusion that even we are, we
madam.
haven't received the instruction
Para
that
7.
whether.
Para 7,
I've-
have you read? Then
Yes,
what
ma'am.
is the what is the confusion now? Para 7
All
is
I-
clear.
I do agree, my lordship. All I pray is let it be like the entire amount need to be paid because there are interests that gonna be add upon. This is the instruction that I have received. That's all my prayer, my lordship. Within 4 weeks, they are ready. They even we are acceptable to be received.
Counsel for the petitioner files an affidavit and submits that he undertakes to clear liability in terms of the averments made in the affidavit. Full stop. Affidavit reads as follows. Learned counsel for the respondent bank submits that if the petitioner were to clear the balance of amount as shown in the loan account within 4 weeks as recorded in para 7 of the affidavit, matter may be disposed of recording the same. In light of the affidavit filed, extracted above, and the stand of the bank, petition is disposed of as settled in terms of the affidavit extracted above, which settlement has been accepted by the respondent bank. Accordingly, petition does not call for adjudication and is disposed of in terms of the settlement. Needless to state, in the event of any default, matter would stand revived.
Please.
Yes.
Much obliged.
Next to serial number 1, Ramesh KR.
For the petitions in this matter, my lord.
Yes.
Note, fourth respondent herein had issued a tender notification dated 1/7/2022, but calling upon the tender for fishing rights for a period of 5 years. In that, my lord, I was arrayed as highest bidder at rupees 14,78,700. Then, my lord, the fourth respondent had issued a notice at annexure B, my lord, calling upon the petitioner to pay the remaining amount, my lord, on or before 1st October 2022. Then, my lord, by the time I reached the office on 1st of October, office was closed. As such, I could not make the payment on
2022.
1/10/20. My lord, your lordship may kindly peruse annexure B, my lord.
No, but now what has happened? We are
Now,
3 years after that.
Please, my lord.
We are already in 25.
But earlier I had filed a writ petition before this honorable court. But this honorable court had directed the respondent authorities to accept the DDs and issue tender orders. In spite of that, they have not issued. Called upon me to once again to pay the amount. Then, my lord, I have already deposited the entire amount. They have adjusted that amount to the second highest bidder and issued the tender in his order to issue tender in his favor. That has been quashed. Now, your lordship may kindly peruse the order dated.
No. Now, what is the
They have issued tender period is not yet over. They have issued another tender notification calling upon the tender for the very same period.
No,
May I submit the facts, my lord?
No, just one minute. We'll see. If it has to be decided some other day, but we'll see.
Now, short point is involved.
No, we'll see. Your tender is extends till which?
It expires on 30th June 2027.
30th June 2027.
Please, my lord.
Yes. Find out.
One submission, my lord. All that what they have done is, my lord, I had tendered my DDs on 3/10/2022. What they have done, they have deliberately, my lord, they have adjusted my DD towards the second highest bidder, saying that I have not paid the amount. Where they have adjusted that and issued an order in their favor. Again, that has been set aside. A direction is issued to issue contract order in my favor. Now, my lord, instead of issuing that, they have called upon me to again, repeatedly called upon me to pay the bid amount again. Then I had brought to the notice of the higher authorities. Higher authority has on this ground alone, higher authority as per annexure L, my lord, suspended the fourth respondent. Then, my lord, again now, they have issued one more tender notification, having accepted the entire amount. In fact, that amount is misappropriated by the fourth respondent. Your lordship may kindly peruse annexure L, my lord.
Have a look at it. Have a look. Look at the order of the coordinate bench at annexure E.
Yes.
Just find out. Relist the matter in the preliminary hearing list on
Monday. My lord,
Tuesday. Yes.
Interim order.
Let us see. Let us see.
Interim order is granted.
Huh?
Interim order is granted.
Interim order in operation is extended till the next date.
Please.
Yes.
My sincere apologies, Your Honor. I was not present in the morning in the first round. My sincere apologies.
Yes.
And my wakalat is being filed in the office.
Correct. Now he is saying that no doubt substantive remedies before the DRT. But he is saying that you have made a false statement to the magistrate court that it is vacant.
Yes, Your Honor.
So what do you say regarding that?
Section 14 of the Surface Act, it is only a ministerial step. There is no adjudicatory process that takes place, Your Lordship, before the magistrate court. So there is no need for a notice for either the borrower or a tenant or any alleged third party before the magistrate court under Section 14 of the Act. And
no, but in the criminal miscellaneous 91.
I am also relying upon a Supreme Court judgment, Your Lordship.
No, but in 9152 of 24. In 91.
Your Honor, Your Lordship may go to page, the first paragraph, in the first page itself, point E and F, it says that jurisdiction of your CMM under Section 14 of the Surface Act is only to assess the secured creditor in obtaining possession of the secured assets, as well as documents related to the secured assets. And at the Section 14 stage, CMM is not required to adjudicate dispute between the borrower and secured creditor or between any other third party and secured creditor with respect to the secured assets. And at page number 12, Your Lordship may kindly look into of the order, Apex Court judgment, at page number 12, paragraph 18.
Yes.
It says, the powers exercisable by the CMM under Section 14 of the Surface Act are ministerial steps, and Section 14 does not involve any adjudicatory process qua points raised by the borrowers against the secured creditor taking possession of the secured assets. In that view of the matter, once all the requirements under Section 14 of the Surface are complied with or satisfied by the secured creditor, it is the duty cast upon the CMM to assist the secured creditor in obtaining the possession, as well as the documents related to the secured assets, even with the help of any officer subordinate to him or with the help of an advocate appointed as advocate commissioner. And at that stage, the CMM is not required to adjudicate the dispute between the borrower, the secured creditor, or between any other third party and the secured creditor with respect to the secured assets, and the aggrieved party to be relegated to raise.
So what is the
objections.
position of the tenant?
Your lordship, I would like to bring it your lordship's notice that the lease itself is not determined. I mean, it is not in subsistence. It is already expired. Your lordship may go to page. It is the lease agreement is from. It is dated 9/12/2020. If your lordship goes to their lease agreement at page number 12 of
No.
their petition.
Now what is the?
I
Just one. What is the procedure for evicting the tenant under the surface?
No, that is if the tenant is a valid tenant. Their lease agreement was for a period of 2 years. As per section 17B of the Registration Act, any lease which is for a period of more than 11 months has to be compulsorily registered. Your Honor, Lordship may look into the lease agreement that they have provided as Annexure A1. It is an unregistered lease.
No,
That's
correct.
the first thing.
Correct.
And second thing is the duration is for a period of 2 years. There is no monthly rent that is mentioned in the lease agreement. At paragraph 3, deposit, they say the lessee shall pay a 14 lakhs by bank transfer in favor of lessor, Mr. Venkatesh Rao, that is the borrower, at the time of executing in this lease agreement. So there is no monthly rent. The lease is an unregistered lease, which has no legal sanctity. The section 14, in case there is a tenant and it is a valid lease, only then notice or should be ordered for the for the people under tenancy. Here there is no valid lease at all, so there is no question of in issuing any notice to them. Actually, as per section 14, it is only a ministerial act. If the bank has followed the due process of law, then the magistrate is bound to just assist the secured creditor to take.
So what is the procedure regarding his advance?
No, that is a lease agreement which is under any other law also, and they have also gone before the civil court. They have filed a.
No, I'm asking what happens to the amount?
Amount that is between the borrower, that is between the alleged tenant and the owner. That the bank has got nothing to do with it. And the mortgage and also the lease agreement that they have entered into is subsequent to the mortgage to the bank. The bank has the first charge in the property here. The date mortgage is dated 25/2/2020, whereas the lease agreement is dated 9/12/2020. So the bank has the first charge.
Now you have taken possession, is it?
We are going to take possession of the property, Your Lordship. And one more thing is, while even before bank has to follow the due process of law, and section 17(4)(a), if Your Lordship could kindly go to, of Surface Act.
Yes. So what is the procedure prescribed?
If it is any tenant or anybody, that is section 14(a).
17?
So I mean, sorry, section 17(4)(a). I'm sorry.
Yes.
Any person in an application under subsection 1 claims any tenancy or leasehold rights upon the secured asset, the debt recovery tribunal, after examining the facts of the case and evidence produced by the parties in relation to such claims, shall, for the purposes of enforcement of security interest, have the jurisdiction to examine whether the lease or tenancy has expired or stood determined. Now,
So,
in this
no,
case,
just-
the lease is expired.
That how we can decide now here.
He himself.
Not in writ jurisdiction. Correct. I am not going to decide in writ jurisdiction any matter relating, let him go before the DRT.
So, Your Lordship, may just kindly hear me once.
No, correct.
It is just a point of law that is.
Not a point of law, madam. You extract a pound of flesh, but it comes with blood also.
That's
We have to be reasonable.
No.
I am not deciding any matter here. So I am not going to decide your defense here, whether the lease is expired or not. I'll send him to the DRT and give him protection till then. Then DRT will take course. Within 6 weeks, it's required to be decided. It will be decided. I'm not going to prolong the matter here. I'll send him directly to avail of the substantive remedy. Let him put forth his case till he puts forth some reasonable accommodation.
But my only argument here is the bank has followed the due process of law. That is what section 17(4)(a)
No,
mandates. That is what the
No,
OS.
what you say, what you say is correct. That's not in dispute. If at all he has any right, or DRT will decide whether it was valid or what. So let him follow that procedure. So I'm not good.
So that the bank will also not be put into.
Now you go there and then you raise it. Protection for how many weeks? 2 weeks I'll protect you. You
Because the
move the DRT.
compliance procedures is very laborious in the DRT, my lords. Maybe
It's not
even-
all that laborious.
Just wait, huh?
maybe 4 weeks, my lord.
That
Three-
would be.
huh.
Because my lords, I've been.
3 weeks I'll give you, good, work out whatever
Please.
remedy you want.
My lords, one more submission is that, my lords, they are saying that affidavit has no value, my lords.
Huh?
They are saying that affidavit does not have any, I just want to make a.
No, which
point.
affidavit? Which
My lords,
affidavit?
in the affidavit, they have said that there is no tenant and the property is in the self-occupation of the.
Where do
borrower.
they say that?
My lords, 81, page number 81, my lords, paragraph 20, my lords.
In our application.
In the affidavit, they say,
Page?
81, page 81, paragraph 20, my lords. The applicant further submits that there are no tenants in the below mentioned scheduled property.
What do you say regarding this?
My lords, what is the value of the affidavit?
Submission is, your lordship, that we have not lied before the magistrate court. Bank.
There are no
is-
tenants.
No, there is no tenancy. Bank has to recognize a tenancy which is valid.
No, madam, this is a false affidavit. You
No.
given a, you let the manager file an affidavit.
They are contradicting in para.
Who has filed the affidavit? Chief manager. Let him explain. Till then, I'm going to keep it
Your
pending.
lordship, I just want to bring another
No,
one
no.
point to, no.
You
I
file
just-
affidavit, I'll
Waiting
see.
for that also, and I just want to bring one more point to this lordship's notice. That is, if your lordship goes to their, a suit is filed for recovery of money. The tenant has filed a.
The
recovery
suit
of
is not
money.
maintainable, madam.
No, he
Ah.
has filed before the city.
Correct,
court.
ignore that.
No. There, they say that they have recorded evidence on 19th of July 2024, they have recorded evidence there. And our bank has issued a possession notice. He says he is a tenant and it is a valid lease. Bank has issued a possession notice on 26/6/2024. And their evidence is dated 19/7/2024. If he was so agreed, would he not have
No, I'm
made
not on
back a
that.
party before the
I'm
city
not on
court?
that point. I'm on the point. Did you verify whether there are any tenants or not?
Your lordship, bank has to recognize the law itself.
That is
mandates
different,
that-
madam. It's factual.
How will we
No,
know?
no.
who-
You should,
how-
don't tell me your persons don't inspect the property.
whether
No,
we
don't take the
inspect
court
or-
for a ride.
No, I am not taking.
You file affidavit, file affidavit. The court, no doubt intends to relegate the parties to avail of substantive remedy. However, it is brought to the notice of the court
Even
that,
the Supreme Court judgment says the same thing which I've.
that, no, I'm saying on the affidavit. I'm going to relegate to substantive remedy. Affidavit, I want an explanation. However, it is noticed
That's
that
the reason I was
affidavit
reading on
was
section
filed
1748.
before the additional chief judicial magistrate by the bank, and para 20 of the affidavit reads as follows. The applicant further submits that no tenants are in the below mentioned scheduled property. Further, it is in self-occupation of the borrower himself. Full stop.
One
The
just last point.
order,
Your
no,
lordship.
just wait. Now the order says it's vacant, is it? Where? Order of the magistrate.
Doesn't mention anything about.
Counsel for the petitioner submits that his rights as a tenant, no doubt, are matters to be raised under section 17(4)(a) of the SARFAESI Act. But however, the stand of the bank amounts to a false submission made before the court. Full stop.
This also may be taken.
Insofar as the substantive remedy is concerned, needless to state, petitioner is required to avail of remedy under the provided under section 17 of the SARFAESI Act, and this court does not intend to enter into the merits of the matter. Full stop. In order to enable the petitioner to avail of substantive remedy, the respondent bank is not to take any further precipitative steps as against the petitioner for a period of 3 weeks from today. Full stop. Next.
Duration of lease is only
In
from
light of
January 2021 to December.
the petition would be disposed of on terms as already referred to above, in light of the settled position of law that the right of the petitioner, if any, is under section 17(4)(a) of the Act. Full stop. However, for the limited purpose of examining statement made at para 20 before the magistrate and explanation. An explanation is required from the deponent. Full stop. Accordingly, the deponent to the affidavit dated 17 September 24 to file an affidavit regarding averment at para 20. Relist the matter on. Meanwhile, you get ready with the main thing. Relist the matter on. When do you want, madam?
Next week,
Date.
25th. And the preliminary.
Your 3 weeks starts now, but in effect, I've disposed it. He'll go there. That explanation one, you give it.
But just 1 second, Your Lordship.
Yes.
The duration of the lease is from 1st January.
No, that we will not decide.
No, no.
It's a factual assertion.
No, no. I am only saying that bank he has not sworn to a wrong, he has not sworn wrongly to an.
That I don't know. That let the chief.
I'm only saying here only, 2020.
Let the manager file affidavit. Let the manager file affidavit. If I find, I'm going to take strict action. You take it from me. Yeah. He's an officer of the bank, and bank must assist the court. There is no personal interest. Interest is to secure your loan, but you can't make a statement which apparently is false. Yes.
N. Sandesh.
See also similar matter, man. Order may pass.
Yes, Jafar, we could.
Yes, sir. It's the same matter where Your Lordship.
So we set aside.
Yes, the auction notification.
Annexure.
Annexure A.
A.
List 1, 235.
Counsel for the petitioner submits that the tender notification has been issued in violation of the priority as per the policy of the state. It is submitted that the notification at annexure A requires to be set aside, reserving, and government may be at liberty to take fresh steps to auction while taking note of the priority stipulated. Full stop. Reliance is placed on the order of this court in WP 16254 of 2025. The order in WP 16254 2025 reads as follows. Next. Accordingly, annexure A is set aside. The liberty is reserved to the state to take fresh steps for auction after taking note of the observations made in the order extracted above. Accordingly, petition is disposed of.
Grateful.
Yes.
List 1. Other arguments, serial number 97.
I've engaged services of senior counsel. In fact, my lords had mentioned that this matter will be taken up at 4 o'clock. If it could be kindly passed over, I'll keep him present before.
We are ready with those synopsis.
You bring him. Yes, password.
Password.
The written submissions made on behalf of R1 is taken on record. Yes.
Please.
List 1, serial number 25. List 1, serial number 25.
List week after next office objections to be complied with.
26.
Text to appear on behalf of Lord petitioner. As a matter, my lord, petitioner, my lord, is a secured creditor. I filed an application under my lord section 14 before the magistrate. That is at my lord page number 61 in the month of May 2024. For my lord, pursuant to my lord 13.2 and 13.4. And my lord, in fact, I sold the property also in favor of the auction purchaser. My lord, what section 14 says, I'll just read the my lord.
I just wanted one clarification,
Please,
not
madam.
related to this
Please,
case.
madam.
In some other matter I was hearing, when you're recovering possession or you go to the magistrate under section 14, there when you're seeking for some possession order,
Please, my lord.
that time don't you have to say these are the tenants?
I have to say. The affidavit, my lord, there is only one document which I'm going. In fact, my lord, section 40 is, my lord, is a ministerial. My lord, he don't have any adjudication power. It's a duty upon the authorized officer to state an affidavit, all the facts.
So if there's a tenant, then 17.
I have to state.
Then 17.4a.
17.4. My lord, I have to state. It's my duty on my whether tenant is, my lord, maybe valid tenancy or not. I have to state before the magistrate under section 14. It's the only one document which I'm going to produce before the magistrate. Based on that, magistrate is supposed to pass out under section 14.
So in the event it is found tenants are there, magistrate may say symbolic possession in case or the tenant will.
My lord, if the tenancy has to be recognized, that is under section 17.4a.
He has to go.
He has to demonstrate before the under section 17.
So the magistrate may keep it in abeyance for some time till he.
No, my duty, I have to, my lord, I have to state in my affidavit there's a tenant. It is my duty. Magistrate may not, my lord, he may not, my lord, go on with the, my lord, whether tenancy is valid or not. Then tenant's duty to go under section 17.4a, my lord, whether it is a valid tenancy in view of, my lord, Harshavardhan Govardhan Sonnagar versus IARC. My lord, in that judgment there are three classifications. One is, my lord, before mortgage. One is subsequent to mortgage until 13.2.
Is that?
Harshavardhan Govardhan Sonnagar versus IARC. Thereafter, my lord, Bajrang Shamsundar Agarwal. There are two judgments, my lord, in respect of tenancy.
Yes.
My lord, it's a matter where, my lord, I filed a section 14. What, my lord, section 14 says, my lord, kindly come to, my lord, the 14.1, where the possession of the secured asset is required to be taken by the secured creditor, or if any of the secured asset required to be sold or transferred by the secured creditor under the provisions of this act. But I'll just skip, my lord, all those things. I'll come to provided. It says that, my lord, within 1 month, the magistrate has to, my lord, take an affidavit. Based on that, he has to dispose of the application. My lord, kindly come to provided after 10. That the receipt of the affidavit of the authorized officer, the district magistrate or chief metropolitan magistrate, as the case may be, shall, after satisfying the contents of the affidavit, pass suitable orders for the purpose of possession of the secured asset within a period of 30 days. My respectful submission before this honorable court in the present matter, my application is pending before the magistrate from last 1 year. Therefore, my lord, I am before this honorable court. Kindly, mandamus, the magistrate pass an order. My lord, in fact, my lord, similar occasions, this honorable court considered and pass an order. My lord, I don't have any other alternate remedy. My lord, in reality, my lord, only, my lord, against my measure, my lord, borrower or guarantor can go. Within 30 days.
We'll have it tomorrow in the.
Great, great.
The EGA. Relist the matter. Now we'll dispense with notice. Notice is dispensed with to the respondents in light of the limited prayer sought for. Relist the matter tomorrow in the preliminary hearing list.
27, Venkatesh's.
Yes.
Covered matter, my lord, for a direction, my lord, to the respondent authorities, Aadhaar card, my lord, details have to be confirmed by the respondent authorities for the purpose of a criminal investigation sought by the investigating officer. The matter is covered. My friend's name is not shown in the cause list. I have
Accept
served
notice, my lord. It is covered, my lord. It can be allowed. But if you can, lordship may have it tomorrow, my lord.
DSGI accepts notice. We'll say Central Government Standing Council accepts notice and you appear for union.
No, my lord. DSGI accepts notice
DSGI
and-
accepts notice for the respondent one and
two, both.
One and two.
1 and 2.
Release tomorrow in the preliminary hearing list. What is the procedure?
Lord, insofar as the Aadhaar credentials to be given to the any authorities, my lord, it can be given, my lord, subject to if your lordship pass an order on that, my lord. In section 33, there is a bar, my lord. Therefore, my lord, the stand taken by the coordinate benches is this, my lord. The one judgment is placed relying upon National Investigation Agency, my lord. The same order was passed that it should be given. And it should be given, my lord, even otherwise.
Which para?
Last operative portion, lords.
No, that section provides 33.
Please.
Isn't it?
Please.
Not at 9, para 9, lord, 9.1.
Yes. So the High Court.
Yes.
High Court must order.
Yes.
After hearing the authority. Release tomorrow.
Initially, it was the district judge, my lord. Therefore, it was amended. Thereafter, it was amended, and it is stated as High Court. Great.
Tomorrow in preliminary hearing list.
Office objection has to be overruled.
What is the office objection?
One is not filed wakalat, filed memo of appearance. That is what is required, not in terms of order.
Office objection is overruled.
The other one is affidavit does not contain signature. It contains signature.
Yes.
The office may be directed to show me. Registry may.
Office to show the name of DSGI as appearing for response 1 and 2.
Great.
Yes.
28, Randeep.
Appearing for petitioner in this case, my lord. There are 5 office objections, minor office objections. I'll comply. Meantime, my lord, matter may be heard. I'm just writ of mandamus, my lordship. It's a writ of mandamus.
Yes, sir.
To respond number 2 and 4 to approve the adoption without insisting the biological father signature because he has waived off his all rights, my lordship, by mutual degree consent. My lordship.
You take out notice.
Yes, ma'am.
Issue notice to the respondents. Petitioner is at liberty to serve standing counsel if any / panel advocate for respondents 1 to 4.
4. 5 is the individual party.
Relist on?
Kindly have it on Friday or.
No, but notice.
Yeah, okay, much.
Next week date. On 2nd in the preliminary hearing list.
Much obliged. Much
obliged. Office objections to be complied with in the interregnum.
Much.
29.
Lordship, they've not served a copy on the government.
Yes.
The office objection.
Serve. We'll have it day after tomorrow.
Have it on day after.
On?
Next week, my lord.
AGA accepts notice for respondents.
No, your lordship, they've not served the copy at all. That's the office objection.
Now he'll do it. Huh?
Take it and complete the office objection.
He's not carrying
Matter in the same stage on.
25th.
By then you serve him copies.
30.
Yes.
Serial number 30, Sudhindra Murthy.
My lords, I appear for the second respondent, caveat. My lords, they have not
One of the objections is regarding the non-service of copies to the caveator, which you have done. But the other objections are very minor. I'll comply with it. There is some urgency in the matter. If I can take up your lordship.
Most important is the petition, amended petition is not filed. He has parted with the property to his daughters. This maintenance of senior citizens act release deed also, which was cancelled, is not produced along with the petition.
Whatever can be filed, they can file it along with their objections.
No, not me.
My part of the arguments.
Release deed is cancelled. The release deed has to be produced. It's the matter concerns the release deed executed by me in favor of my son. That is not produced in the petition. That is cancelled by the assistant commissioner. Without producing.
No, just what is the impugned order?
Milords, may I just say this, Milords? There was a suit filed by the petitioner's son against the second respondent father in relation to a sale transaction of 2018 where joint family property was sold without accounting the same to one of the sons. As a part of a settlement arrived at for the withdrawal of that suit, 3 documents came into existence. One is a release deed, second is a 2 memorandum of understanding, one is registered, the other one is unregistered. All the 3 documents are contemporaneously executed, forming part of the same transaction, as a result of which the suit is withdrawn. It is after the suit is withdrawn as a part of this settlement, an application is made under the Senior Citizenship Act saying that this document is covered under section 23, therefore it should be cancelled. They are not, they are refusing or not looking after the old father. We entered appearance and filed our objections, raising 3 contentions. One, it's a part of a larger settlement. It cannot be revisited under the provisions of the Senior Citizens Act. 2, it is a release deed. It is not in the nature of a gift deed because these are the properties in respect of which we have a pre-existing right. Therefore, this is not permissible to be done under 23. The third contention which we raised is not that this property as such is not capable of being bifurcated in the manner in which it is required to be sought for in the application. Then what happens?
No, just 1 minute. What is the order passed?
No, the order passed is ground floor should go to the father, second respondent. We should take the first floor. Lordships, may kindly have a look at Annexure R9, page 130. For 1 second, my lords, I'll just take your lordships to what is the difficulty.
No, the matter requires consideration. In all of these matters, because under 23, it's an order of the civil court, literally.
It is in substance.
Just. So I will, in normal course, I'm staying it. Now,
page 138, your lords. Sorry,
and the normal course, since we are staying that order, normally we are directing some payment of.
I'm ready, my lords. I'm ready.
This is not a matter of that nature. My lords, this is not a matter of that nature. He is 92-year-old. He is not permitted into the kitchen of the house. His cook is also removed. It is not a matter of that nature. It is a serious matter, my lords. He is staying in a different apartment now. He is not permitted inside the house. 50 square bungalow he has constructed.
May I just pass on the copy of the orders of the coordinate bench in relation to the same matter which had come before this coordinate bench? May I just pass on? There is already an order passed.
May I just this is a fraud, abuse on the process of the court. I will demonstrate, my lord, dishonorable court and direct the assistant commissioner calling him to the court, and my lords, dishonorable court directed the assistant commissioner to be present in the court. 1 year they didn't file objections. Now they are asking for interim order. Kindly see the orders of this court in the earlier writ petition. I filed a writ petition directing the assistant commissioner to pass orders. 1 year they didn't file objections before him. And kindly see what is under challenge. Page 37, my lords. Release deed is cancelled. That is not produced. The release deed is not produced before this court deliberately. Along with the writ petition, they have suppressed the release deed, my lords. No interim order can be granted in a matter of this nature. Your lordship may have it tomorrow. Let them produce the release deed. I will argue the matter for 5 minutes, my lords. 92 years old. He is waiting for his death. The petitioner is waiting for the death of his father. Very unfortunate, my lords. Your lordship may kindly have it tomorrow. Let them produce the release deed, my lords.
No, now,
this is not a matter in the usual.
No, correct, maybe, but the order cannot be implemented till we decide. That's all. I'm not going to say anything.
Kindly see two things, my lords. Kindly see page 37, my lords. What is cancelled? Kindly see page 37. Normally, I don't disagree. Interim order has to be, kindly see page 37. What is under cancellation, my lords? Kindly see page 37. Release deed dated 17/2/2021 is cancelled. That is not produced in the writ petition. How can the matter be heard, my lords?
Just a oversight, it is not produced. I
No,
want
no,
the
no.
copies.
No, and second thing, my lords,
We'll have it tomorrow.
second thing, my
Very
lords,
well, my lords. No difficult.
The matter
you
in
are-
the
you are-
preliminary hearing list tomorrow.
Lordship, so grateful. Lords.
Lord, the copy will be served, my lord.
Yes.
my lords, one more thing, my lords. One more thing I
Yes.
want to bring to the notice of the kindly annexure order of the allow me to make submission.
Tomorrow,
Mr. Ravishankar,
tomorrow.
I know you are in
Nale.
my lords,
Tomorrow.
allow
We'll have it
one
tomorrow.
submission.
We'll have it
ಇನ್ನೊಂದು
tomorrow.
ತಪ್ಪಿದೆ ಅಲ್ಲ annexure A page 21 may kindly be seen. ಕಾಸ್ಟ್ ಐಟ್ಲೆ ತಪ್ಪಿದೆ, ಅದಕ್ಕೋಸ್ಕರ ಹೇಳ್ತಾ ಇರೋದು.
ನೋಡ್ರಿ ಏನೋ
Just
ಅವ್ರು ಹೇಳಿದ್ದಾರೆ.
Ravi Shankar, look into it.
I will I've taken note of what Mr. Arun consults. I'll get it rectified by tomorrow.
Not be too sarcastic in with respect.
Arun is saying that what has to be done has to be done. Yes. Yes.
For office objection compliance, will comply in a week's time maybe. Week's time.
Weeks time granted for compliance of office object.
32. My lord, in fact, my lord, the challenge before this honorable court, the order passed by the DRT. My lord, the
Section 17.
that my lord is not
Interim
That's
application.
all.
Interim application. My lord,
Will dispose it.
it could be disposed of, my lord, with a grant of time, my lord. What I'm asking for is a education institution, my lord.
No,
My lord,
no. Correct. Now you intend to challenge.
please, my lord.
So time spent between filing and now will be taken note of for limitation.
It's an interim order, not the final order, my lord. Section 17 ಅಲ್ಲಿ final order challenge, my lord, appeal is available, section 18, my lord. But interim order where I'm seeking for a modification of the order, my lord, seeking extension of time. Interim order conditional order in comply ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ರು, ಅದಕ್ಕೆ ನಾನು ಟೈಮ್ ಕೇಳ್ತಾ ಇರೋದು. Partly complied and partly not complied. For the balance payment, my lord, what I'm asking for is only
My lord, what had happened, my lord, I issued a possession notice. My lord, that I said before the DRT in SA number 170 of 2025. The Honorable DRT passed an order on 13/3/2025, subject to deposit 25% of the money, my lord, they granted a stay. My lord, we they are not complied. My lord, the Honorable DRT vacated the interim order in view of, my lord, non-compliance of the order made by the DRT. My lord, against that order, my lord, they approached this Honorable Court, my lord, seeking modification. My respectful submission, any order passed under, my lord, section 17, this is alternate remedy under section 18. Therefore, my lord, my lord, the writ petition is not.
My lord, it's only not the, it's not a final order, my lord. Final order ಆದ್ರೆ challenge appeal ಇದೆ. Section 18 ಅಲ್ಲಿ. Interim order ಅಲ್ಲಿ what I'm asking for is only extension, my lord. ಇನ್ನು ಒಂದು ತಿಂಗಳು ನಾನು ಅಲ್ಲಿ ಹೋಗಿ DRT ಗೆ ಹಾಕೋದ್ರೊಳಗಡೆ and there it mandates the pre-deposit, my lord. 50% ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕು. ಇಲ್ಲಿ 25% ಅಲ್ಲಿ ಅರ್ಧ ಕಟ್ಬಿಟ್ಟು ಇನ್ನೊಂದು ಅರ್ಧ ಕಟ್ಲಿಕ್ಕೆ ನಾನು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳ್ತಾ ಇದ್ರೆ ಅಲ್ಲಿ 50% ಕಟ್ಲಿಕ್ಕೆ ಕೇಳಿದ್ರೆ is it not a additional burden on me?
You're going to clear the entire
25% ಏನ್ ಕಂಡೀಷನಲ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಅದಕ್ಕೆ ಬ್ಯಾಲೆನ್ಸ್ ಪೇಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಐ ಆಸ್ಕಿಂಗ್ ಫಾರ್ 2-3 weeks ಟೈಮ್, my lord. ಎಜುಕೇಶನ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಸ್ಟೂಡೆಂಟ್ಸ್ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ರೆ ನಾನು ಇಮಿಡಿಯೇಟ್ಲಿ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
Which is already got vacated by the DRT.
ಅದೇ ವೆಕೇಟ್ ಮಾಡಿದ ಅದಕ್ಕೆ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಂದ್ರೆ ಫುಲ್ ಪೇಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಐ ಆಮ್ ನಾಟ್ ದ ಐ ಶೋನ್ ಮೈ ಬೋನಫೈಡ್ಸ್ ಬೈ ಮೇಕಿಂಗ್ ಪಾರ್ಟ್ ಪೇಮೆಂಟ್, my lord.
At least let them file an affidavit before this honorable court. I'm going to pay the entire money within 3 months or something, my lord. I may take an instruction. I may direct it to take instruction.
yes. You find out.
Please, my lord.
Relist. Vignesh Shetty accepts notice for the respondent. Relist on
Monday.
preliminary hearing list on Monday.
Grateful.
It must be unambiguous and clear.
Please.
Grateful.
Your offer must be unambiguous and clear.
Please.
Yes.
32.
My lord, this is a matter where, my lord, auction purchaser, my lord, amount has been forfeited by the bank, my lord. When there was a defect on the part of the banker itself, my lord. ಖಾತಾ ಇಲ್ಲ ಪ್ರಾಪರ್ಟಿಗೆ, ಟ್ಯಾಕ್ಸ್ ಪೇಮೆಂಟ್ ಮಾಡಿಲ್ಲ. ಸೊ ಅದನ್ನೆಲ್ಲ ನಾನು ಡಿಟೇಲ್ ಆಗಿ ಕೇಳ್ತೇನೆ. 25% ನಾನು ಕಟ್ಟಿದ್ದೇನೆ, ಬ್ಯಾಲೆನ್ಸ್ ಪೇಮೆಂಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಯು ಗಿವ್ ಮಿ ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್ ಅಂತ. ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕನೆಕ್ಷನ್ ಇಲ್ಲ. ಸೊ ಇದನ್ನೆಲ್ಲ ರೆಕ್ಟಿಫೈ ಮಾಡಿ ಅಂತ ಮೇಲ್ ಕಳಿಸಿದ ನಂತರ ದೇ ಫಾರ್ಫಿಟ್.
Issue notice to the respondent.
Please. Great.
33. Sangamesh.
Emergent notice.
Emergent
ಡೇಟ್
notice.
ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಸುಮ್ಮನೆ ಇಲ್ಲ ಅವ್ನು ನೆಕ್ಸ್ಟ್ ವಾಪಸ್ ಆಪ್ಷನ್ ಬರ್ತಾರೆ.
Week after next.
ಗ್ರೇಟ್.
Yes.
But 33 is connected with another writ petition.
Just wait. ಇವಾಗೆಲ್ಲ ಕರೆಕ್ಟ್ ಅಷ್ಟೇ. ಡೇಟ್ಸ್ ಕೊಟ್ಬಿಡೋದು. ಕೊಡು. Board is being discharged. I have to rise by 3:45. Whatever submissions you want to make, dates you want to ask, you can please make a mention. Dates, just 1 minute.
Maloj, item number.
Just 1 minute. Just wait, just wait.
33. Lords, 33, Lords, it may be listed with.
Fresh matter, is it?
It's a fresh matter.
List
Lords,
the matter.
79 is also connected, Lords. Both may be posted for.
33 along with 79 in fresh matters list. 23rd.
Tomorrow, Lords.
23rd, let us see.
Lords,
Yes.
there is some urgency, Lords. I have to get a work order in that, Lords. Tomorrow or day after tomorrow, Lords. In spite of the
20th.
20th. Lords, the interim order may be extended in 79, my Lords.
79 interim order earlier granted is extended to the next date.
Maloj.
34.
My lord, seal number 34, my lord, appearing for respondent.
Fresh matter, is it? It has not come before court once also. Petitioner submits, office objections are complied with. List the matter in fresh matters list on 23rd.
My lord, I pray for additional
item
week's
number
time, my lord, in
21 for the
34.
orders.
Let
For
us see.
respondent.
On that day you ask, we'll see. Next.
35.
Week. Huh?
Maloj, item number.
Just.
35.
The order passed by the Human Rights Commission, 35.
No, correct. We'll have it. List fresh matter.
Yes, my lord.
List in fresh matters list on.
23rd.
Yes, next.
36.
Office objection is stated to be complied. Complied. List the matter in fresh matters list on.
23rd.
Yes.
27.
My lord, office objections are complied, my lord. It may be listed in the fresh list.
The petitioner submits office objection complied. List matter in fresh matters list on.
23rd.
Yes.
38.
When do you want? Office objection complied with. List the matter
24.
on 24th.
39.
Yes.
Parole TA.
When do you want? List. I did good. 24th.
40.
Yes.
Nandan,
I pay for respondent, my lordship.
Yes.
They have approached the OTS and they have not paid initial amount, my lordship, and they have come before this court. And after approach,
List the matter in preliminary hearing list.
First.
You can dispose it off, isn't it?
Please, my lordship.
Along with office objections on.
24th.
List on 24th in preliminary hearing list. Office objections to be complied with by then. Yes.
41. Santosh.
Office objections to be complied with within a week.
42.
Same order.
43. 43.
And relist the matter tomorrow in preliminary hearing list. Yes.
44.
44, I have complied office objections, Lord. Kindly have it before 23rd, my lord.
Office objections stated to have been complied. List the matter in fresh matters list on.
23rd.
Yes.
45.
I'm for the petitioner.
Complete the order of this order.
Yeah.
Question is handed over.
Have it by Monday, Your Honor. I will tell you all them.
So now it has to come in preliminary hearing list.
Yes, Your Honor. Yes, Your Honor.
No, list matter in preliminary hearing list, short date.
24.
On 24th.
23rd.
46.
Yes.
46. Vinod Kumar.
List them. Office objections to be complied within a week's time.
47.
47, I'm for the respondent, my lord. Kindly have it on Friday, my lord. It's a senior citizen matter, my lord. I filed a vacating stay.
Let's see, vacating stay.
Yes, my lord, because he's suffering.
The list on
Second.
second. Yes.
Before any date, my lord.
8.
So it has been complied with, I filed a memo.
List in preliminary hearing list on. Get ready to go to DRT on the next date.
July.
Yes. Let us see.
49.
Yes.
Pavana Chandra Shetty.
My lord,
First of
already,
Date is given.
1st of July.
already
Yes.
there is
Yes.
already there is an order for posted for preliminary hearing. However, my lord, it is mentioned in the office again, it is posted for order. Kindly have it for
List
preliminary hearing
in
tomorrow.
preliminary hearing list tomorrow.
50. 50.
He's gonna follow all the 90 matters like this.
List, preliminary hearing list.
19.
Yes.
51.
I am for the respondent. He has not complied, your lordship. Thrice the matter is posted. They are not complied.
Yes, Your Honor.
The 1 crore 35 is the due.
Local honor. Otherwise, they are one-time settlement, Your Honor.
No, your lordship.
We are
Yes.
ready to file.
Relist in preliminary hearing list on.
Please.
24th.
Yes.
52.
Modern date.
Your lordship, they are not complied. Interim order.
Huh? They are not complied.
Not complied.
51 interim order ಬಗ್ಗೆ ಏನು ಹೇಳ್ಬೇಡಿ.
52.
No, that's a different matter. Yes.
52.
Yes.
52 Mayur.
List week after next.
53.
My lord, appearing on behalf of the petitioner, my lord. My lord, we have already taken process with respect to all the respondents. It is returned back
Office to petitioner take fresh steps.
second time.
Yes.
My lord, interim order may kindly.
Interim order operation extended till next date.
54.
54, my lord, kindly have it day after tomorrow. I am suffering with interim order. It is a date given matter. In fact, it was supposed to be listed yesterday. Today it is listed.
Relist
23rd.
on 23rd. Yes.
55. Sampath.
Withdraw. Petitioner files a memo. In light of the same, petition is dismissed as not pressed.
56.
Office to put up report regarding notice issued. Relist the matter on
7th of July.
Yes.
57 and then 58.
Relist on 2nd of July. Same
59.
59.
2nd of July.
Yes.
60. Girish P. Waldar.
ನಾಳೆ ಇತ್ತು. Relist tomorrow in preliminary hearing list.
61. 61.
Relist. I ignored it. Relist on short date 23rd.
60,063.
Relist on
2nd of July. 64.
Relist on
2nd of July. 65.
65 appear for impleading applicant, my lordship. 19. There is urgency in this matter. My lordship, it's pertaining to temple matter where the development committee has had.
short date.
27.
Yes.
My lordship,
66.
66 for the petitioner, my lord. Any short date, my lord.
Relist on
My lord, the interim order may be extended.
interim order in operation extended.
67.
Any date, my
My
lord.
lords, I appear for respondent number 5, my lords, in the 67. My lords, last date of hearing, my lords, my lords, the petrol pump matter, my lords. And the, my lords, the government has to be, my lords, say, my lords. Now, my lords, petition also is not maintainable as per, my lords, dishonorable court judgment, my lords. It's only, my lords, small issue, my lords.
Short date. Relist.
This week, any date, my lords.
26.
23rd, my lords.
Interim
26.
interim order in operation extended till next date.
68, 69 and then 70. 70.
Relist on
2nd of July. 71.
relist.
7th of July. 72. Lilapi.
Relist.
7th of July. 73. Latif B. 7th of July. 74. 75.
75, I have filed before. My name may be shown, my lord.
Show the name of Learned Council SS Haveri for R4. Relist. Date code.
26th.
Yes.
76. 76.
2nd of July code.
2nd of July. 2nd of July. 76.
Relist in preliminary hearing list on
24th.
Yes.
77,
For the petitioner lordship, may we
My
take
lord, I fear for respondent. Any date apart from 23rd, my lordship.
Relist on.
3rd of July.
Yes.
78.
Much obliged.
My lord, in this case, I am for the respondent. Surface matters, my lord, the stay has been taken.
Relist in preliminary hearing list on.
25th.
Yes.
79, Sangamesh.
Adaital. Next.
80.
Relist in preliminary hearing list on.
26th. 81 urgent. Settlement 82 urgent. 83.
I represent petitioner in this case, my lord.
Relist.
The last occasion, my lords, I have filed NOC wakalat on behalf of petitioner, my lords. However, my lords, my wakalat has been taken for R3, my lords.
Learned
I had
office
filed
to
NOC
show the name of learned counsel Vidya Selvamoni for
Chitralingeshwara
petitioner
Vidya Samstha is petitioner, my lord.
for as representing the petitioner.
Yes, my lord.
Yes. Yes. Relist on.
That's my.
84, V. Mohan.
That's one submission notes in 83, my lord.
No submissions. It will come on the next date you make.
84.
Any particular date?
7th of July. 84. 85. 85, then 86.
90.
87.
Date code.
88.
All dates will be given by the court officer. There is some official function. So I can't now hear. Beyond this, dates you can ask for the court officer. I have given him discretion.
My lords, there's one last submission. My lords, in item number 21, my lords, I yesterday, I come from Delhi. My lords, it's my engagement day after tomorrow. If your lordships may kindly put up the matter for 30th of June, and meanwhile order the bank to maintain status quo, my lords. We are in process of repaying the bank as well, my lords. We have paid 1 crore more, my lords. If your my lords, it's my engagement day after tomorrow, my lords. 3 days I've been living in Bangalore.
Give you a date, but if Vignesh must say yes, then we'll see.
My lords, Vignesh,
My lord,
Mr. Vignesh is there, my lords. Your lordships may kindly
with
see
regard to the
Mr. Vignesh is there.
warning list, my lord.
Just
my lords, let them.
Just 1 minute.
We are, my lords, we are. My lords, let them maintain status quo, my lords. Let the property be with them.
He's saying he has not done anything as on date. By the next date, maybe nothing may happen. So we'll have it on that day.
My lords, let them maintain a status quo, nothing else. My lords, I'm ready to repay the bank.
He's there now. Vignesh is nodding his head that nothing may happen. You wait till the 30th.
My lords, if your kind words may be incorporated in an order, it will be helpful, my lords. My lords, my request is to put it for 30th of June if it is possible.
30th. Dates will be
My lord,
if your lordships can put it for 30th
my
of
lord,
June.
serial number 67 in the warning list, my lord. This matter may be come with a regular list, my lord.
Sir, 30th of June.
30th June.
For item number 21 in the orders.
Yes, sir.
30th of June it is. Grateful.
ನಮ್ಮದು ಕರೆಕ್ಟೇ ಇಲ್ಲ ಲಿಸ್ಟ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅದರ ಡೇಟ್ ತಗೊಂಡ್ಬರ್ತಾರೆ ಮೇಡಮ್
Court officer?
Court officer?
Court officer?
Court officer? ಕೋರ್ಟ್ ಆಫೀಸರ್ ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ಏನಾಗುತ್ತೆ ಅಂತ ಒಂದ್ಸತಿ ನ್ಯೂಸ್ ಬೇಕಾಗಿತ್ತಲ್ಲ. ಕೇಳ್ತಿಲ್ಲ, ಮ್ಯೂಟ್ ಆಗಿದೆ. ಕೋರ್ಟ್ ಆಫೀಸರ್? Court officer.
Court officer.
Court officer. Court officer. Court officer.